Rồi. Bữa nay là nói chuyên về asset protection đó anh Dan.
Dạ, that's it. Không có gì khác trong dòng. LOC, Serial C gì đó.
Mình đã ra public chưa?
Rồi. Ok,
Dạ,
lại
rồi.
rồi.
Dạ, một xíu tại live, một xíu nữa có người.
Chị hỏi em câu đó em tưởng là công ty của em rồi bự lớn bự như mình đã ra public chưa đó. Em có gì trả lời rồi.
Em sắp lên Nasdaq đóng cái đóng bon.
IPO là chị bám càng thắng nha.
Công ty bất động sản khó bị IPO quá, high tech dễ hơn ạ.
Không có hết hả? Em sửa lại.
Mọi người khỏe không? Hôm qua làm việc khuya quá hả?
Phải ơi.
Yeah, I'm guys. Yeah, hơi về mệt quá.
Nói cho mệt rồi. Hôm qua là meeting gì từ 2 giờ trưa đến 8 rưỡi tối không nội.
Bao nhiêu phần là trừ thuế được, bao nhiêu phần không trừ thuế được vậy?
Một phần nào trả hết rồi. Everything.
Yeah. Good morning bạn ơi. Mấy bạn mà comment ở bên Facebook group nhà cửa Mỹ nó không có hiện cái tên lên, nó chỉ để Facebook như user thôi. Tại cái group của mình là group private đó. Cho nên mình cũng không biết ai. Nên phải mở lên cái group bên kia mình mới thấy được. Mình đã live rồi. Mình đợi luật sư vô nha các bạn.
Ok, Thắng với Dan chào các bạn. Mình đi gọi luật sư đây nha.
Ok. Rồi các bạn ơi, đây là chương trình livestream thứ 6 hàng tuần, podcast thứ 6 hàng tuần của nhà của Mỹ. Mình đang livestream trên 5 platform. Các bạn có thể coi từ Facebook cá nhân của mình, Facebook cá nhân của anh Bob vô nè. Anh Bob vô rồi kìa chị.
Hi Bob.
Hi, how are you?
Hello Bob, how are you?
Good.
Good morning.
Getting set up here.
Right.
How's everyone doing this morning?
We're doing okay. Thank you.
All right, it's just Pacific time, 7:30. We just woke up.
Let me finish the introduction real quick, okay? Thì giống như mình đã thông báo với các bạn rồi, thì hôm nay mình có luật sư Bob là chuyên về real estate. Thì hôm nay các bạn đặt câu hỏi về chuyên đề thôi nha, đừng có đặt về mua xe mua cổ tùm lum là chuyên đề thôi. Thứ 6 là trình cho chuyên đề là các bạn có công ty, các bạn có LLC, cách nào để bạn bảo vệ tài sản của mình, lập nhiều LLC, lập một LLC đó, những cái chuyện thưa kiện như thế thì các bạn có thể đặt câu hỏi trực tiếp trên cái platform bạn đang coi và mình sẽ đọc được cho luật sư. Rồi, ok. Mời anh Dan cũng như bình thường, anh Dan dẫn dắt câu chuyện đi.
Okay, good morning. Thank you, Bob, for joining us today, sharing with our community. We want to know how we can protect our assets, especially real estate. A lot of the people in my community, they like to, when they buy a house, they keep the house under their name or the sister name or aunt, uncle name. What's the best way to keep your asset under what name or what LLC or I trust? Can you share with us, Bob?
Good morning. Absolutely.
So, Chicago. It's cold.
Yeah, well, it's cold. A little cold today, but we're at the end of it. I think we're at the tail end here. There's a lot that goes into that. So it's number one, before we even get into what the options are, I just want to make sure everyone's clear. When you are buying a property, really depends, number one, on what kind of liens you have against the property. So if it's like your primary residence, something like that, the mortgage does require that it be in your name, whoever signed the mortgage. Now, if you signed the mortgage through your LLC, then you're off the hook. You can put the deed in your LLC and you're all set. If it's your primary residence or investment property and you had to sign for it personally, you're a little bit limited there. So you're not really supposed to, at that point, put in an LLC. I'm not saying that people don't, but you're not supposed to. Now, the quickest way to get around that is there's a law called the St. Germain Act where you are allowed to put your property into a trust. So that doesn't trigger anything with the mortgage. You can put any of your properties into a trust at any time and you're ready to go. So that part's fine. Now, and we're going to talk a lot more about this because I'm looking at some of the questions that people submitted ahead of time. There's a lot of really good questions here. We're going to talk a lot about the difference between putting something in an LLC or putting it into a trust. I'll say right at the beginning, a trust is good for asset planning from the perspective of preparing your estate. So if something should happen to you, how your estate's going to be handled. So it goes to your family, to your spouse, things like that. It doesn't necessarily protect you from creditors totally. It hides it from them, but doesn't totally protect you from it. The only way to really be sure that you're protected from any creditors trying to go after your property is to have it in an LLC. Now, the trick there becomes the balancing act of when we can put it in an LLC, when we can't put it in an LLC. And really, ideally, you almost want to overlap them. You want to have a trust and you want to have an LLC. You ideally would like to have both. So I know that's not really the full answer to the question, but that's what we're going to go through here today. We're going to go through all those different options.
That's perfect. So I understand that it's if you have a loan on a property, the bank doesn't like that. It's under, if you're the grantor, they don't want it to be under LLC, correct?
Well, when you look at your mortgage, when you're going through it, when you sign it, one of the provisions in there is that the property is supposed to stay in the name of whatever person is signing the mortgage. So that goes for anything. I mean, if you own a property, if you buy a property and you personally, the only person who signs a mortgage, then after the closing, you deed it in your brother's name. It's the same thing. You're not supposed to do that. Now, again, I'm not saying that people don't do that. I get that. People do that kind of stuff sometimes, but you're not supposed to. And if the bank finds out about that, you can get in trouble. It is technically it's grounds for, if the bank discovers that you did that, grounds to accelerate the mortgage and declare you in default. Reason being, they want to make sure whoever's on title is the person who's responsible for the mortgage. You're not supposed to be changing it around. So, but what I have seen clients do, and I can't recommend this because technically you're in violation of the mortgage, or at least I give people this preface at the top. Usually, if you pay your mortgage for a while and you develop a good relationship with the bank, I have had many clients deed the property later into their LLC. Now, under the premise of, look, I'm the person responsible for the property. It's my LLC. I'm deeding it into the LLC. The bank's never going to give you permission to do that. What's the phrase? I'd rather ask for forgiveness than ask for permission. People do it. You're not supposed to do it, but a lot of people do it.
So let me get this straight. It's two different things. This is the relationship between you and the bank, which you're not supposed to do it. There's a contract between the bank. They're not supposed to do it, but for the protection side, it still protect you from the liability and stuff like that if you put in the LLC, correct?
Correct. Yeah. I mean, ideally, you want to have your property, especially if it's an investment property, you want it in an LLC to give you the most amount of protection that you can have. I mean, that's the ideal scenario.
Right. Perfect. So technically, everything that you own, like that real property, you shouldn't have under your name. Everything should be in an LLC or a trust, correct, Bob?
Ideally, you don't want anything in your name. So at some point, you should have everything either in the name of your LLC or one of your LLCs, or have it in a trust. But in a perfect scenario, no, you really shouldn't have anything in your name. Now, we all do. There's different scenarios where you end up with stuff in your name. But it's advisable to get everything out of your name.
Right. Can you explain to us like what's the difference between a trust and an LLC?
Yeah, so they're very different from each other, and I get that question a lot. It's very interesting. A trust and an LLC are very different animals. Um, f- r- the best way I can explain it is the LLC is really for asset protection. The trust is a part of your asset protection, but it's really a document for estate planning. So estate planning means the documents that you prepare in case something should happen to you, in case you should die tomorrow. The documents to determine how we're going to handle your affairs. So a trust is really intended to be for that. Now, the reason that people use both, number one being people sometimes we'll use a trust as a form of asset protection. It's really not supposed to be that way. But the reason people use it is um, when you set up a trust, you can set up a very generic name for your trust. Now, some people will set up a trust in their family name if it's, the trust for your asset or for your estate planning, but you can also set up a very generic name. So you'll see like a land trust or a living trust, and it'll just say the 123 Living Trust, or the land trust of 8765431, something like that. It has a very generic name. So it can make it very difficult to figure out what assets you own. Now, when you sue someone, if I file suit against you, I can request through discovery that you disclose any assets that you have a beneficial interest in. So it's not a foolproof. If you get into a situation where someone's really going after you, they can still discover that you have those assets. But if I'm searching for your assets and you have set up a piece of property where it's in a trust, it could be very difficult to figure out. So what you're trying to do is frustrate people where it's hard for them to figure out that you own the property. So it's not a foolproof asset protection, but it does make it difficult to locate you. Sometimes very wealthy people will ask me to set up a very generic trust so that it makes it very difficult to figure out where they live. Some people just really don't want anyone to know where they live. Some people, very famous people, sometimes will set up a generic trust because they don't want people to know that they have several different properties. I've had people don't really care about their primary residence, but they really don't want anyone to know about where their vacation home is. Things like that. Or another good example is sometimes when we're dealing with celebrities, like when like a NBA player or NFL player, someone like that, when they want to invest in property, they need to do all these layers. They need to have the trust with the LLC because they don't want everyone knowing that they're involved with this property. They just want to they don't want their name on the front of this investment. And, then it kind of, attaches to them and it makes things awkward. They would rather no one know that they're involved with it. So there's a lot of anonymity involved with it. They want to be completely anonymous, that they have any involvement with this whatsoever. So we use that a lot with trust. You want staying as anonymous as possible. With the LLC, there is some level of anonymity involved with the LLC. So you could set it up in a ways where no one really knows that you're involved with the LLC. It is possible to do it. There's a very specific structure with that. But I do have people sometimes will say, hey, I want to be a partner in this LLC. I don't want anyone to know about it. I say, okay, we have a way of doing that. So there's that. But the LLC is really what shields you. So an LLC is a shield that protects you for asset protection purposes. So if someone sues you and you're liable, so you're going to lose, and maybe you only have $100,000 of equity in this property for them to take, but maybe you've lost a personal injury lawsuit, or someone died at your property, or something horrible happened, and they have a judgment against you for $1 million. Well, you're only limited to the assets within that LLC. So you just say, okay, well, here's the deed to the property, but that's it. That's as much as you're liable for. So that's what you want. The only way that can go beyond that is if something really like if you committed some sort of fraud, Sometimes they can go outside of the LLC if you really did something really bad. I mean, that's a pretty high standard. You have to have done something really, really bad. Otherwise, you're limited to that LLC. Now, you lose the assets in that LLC, but they can't go after you personally for your personal assets. And that's what you really want.
Perfect. So basically, when you said LLC, you shouldn't put under your personal name, right? So for everyone can recognize you, because a lot of people, when they open LLC, they were like, "Hey, my name is Dan," so I put Dan, Dan, or at LLC, so everyone knows you. Kind of defeat the purpose of hiding an asset, or
well, it depends on what you're trying to accomplish, right? It really, whenever you're doing any of this, and it's really where I start when I meet with a client. If it's someone says, "Hey, I want to invest in real estate. I want to set up a partnership. I want to set up an LLC. I want to set up a trust. I want to invest. I want to do any of these things." The first question is really, what's your goal? What are you trying to accomplish here? And then everything comes after that. So, in order to answer that question, each person listening to this, I would say, what is your goal? What are you trying to accomplish? So someone may say, I want to invest in real estate. I want to have no involvement. I don't even want to know anyone I'm involved with it. I want to be completely silent. I don't want anyone to know I even did this. Then you go that route. Some people will say, look, I'm investing in real estate and I want everyone to know that I'm doing it because I want them to know about my company. I want them to know what I'm doing. I want them to maybe invest with me to know what I'm doing. And then in that case, you want to plaster your name all over it. You want to brand what you're doing. Delphine, using Che, investing in Che to get exposure with syndications and things like that. You want to, brand what you're doing so that people can find you. So it really depends what you're trying to accomplish.
Do you have anything to add, Delphine?
Go back to the trust name. In my understanding, it's an art too, because the trust is to shield your assets, right? So people cannot find you. So sometimes you should name it at a way that they don't want to touch you. Their attorney look into multiple trusts and see where they can find a victim. And then when they see the name that's so intimidating, they don't want to touch it. So it's an art to choose the trust name. Am I correct, Bob?
There's an art to it. Well, really the art to it becomes setting it up perfectly in a way where it is next to impossible to figure out that this asset is attached to this person. If you do it perfectly, it is so incredibly hard to figure out that someone owns that piece of property. If you have it in the trust, you have everything registered to the trust. The tax bill, everything goes only to the name of the trust, and your name doesn't appear anywhere on there. I mean, it will frustrate people to no end. I mean, you can make it very, very difficult to figure out that anyone owns a parcel of property if you set up that trust the right way.
Most of landlords don't want the tenants know where you live, your contact info. So between trust and LLC, it will do the job, to shield, to protect your assets.
I mean, both will accomplish that. It's just the way you want to set it up, but both can accomplish that. I'm not going to lie. I have some clients, it cracks me up. You really think about wanting to be a property investor and wanting your face in front that, look, I'm the owner of the property. I have some people that take the opposite approach. I have some people that want to set everything up where no one has any idea who owns it. And when the property owner goes to the property, they tell the tenants, "Oh, you know what? Look, I'm just a property manager. I'm not the guy that makes the decisions. The landlord in the back, he's really on my butt. So, I'm really sorry. I don't make these decisions," because they don't want to have to, let the tenants know that they're the ones making that call. They blame it on, the Wizard of Oz, the guy in the background who doesn't really exist, and they're not the ones making that decision.
Definitely. And also one question for you, Bob. like, should investor put an LLC on each property, or they can combine a few properties and put it under an LLC because there are costs involved in each LLC?
A really good question. That's I get that all the time. That's a debate. So the way I usually gauge that, the way I usually answer that question is, first, you need to decide what your allocation of risk is for your portfolio. So you have to make a decision how much, how many assets or how much of your assets are you willing to put um, to be exposed to each other, to cross collateralize within each LLC. So, is that $1 million? Is that $2 million? Is that 2 properties? Is that 8 properties? So usually it's a balance of, I usually say price point, and then number 2, I'll usually tell people asset class. So asset class probably should come first. So what that means is you don't want, the classic example is, first of all, if you're going to be engaged in any sort of contracting or flipping of properties or anything like that, I don't want that anywhere near your long-term assets. They have no business being in the same LLC with each other. So I'll have people where they come in and they say, okay, I have 8 single family homes I have rented, and then but some of them I flip. And I say, before we do anything else, those 2 things need to get separated from each other, because you carry a different amount of risk with, doing contracting. Something can go wrong. If you're flipping houses, maybe you didn't do something right, and then the people come back and sue you. You don't want that to have exposure with your long-term assets, because if something goes wrong with the flipping, you don't want them to attach to those investment properties that you had intended to keep for 20 years. So anything where you have short-term profits and long-term profits, those need to be completely separated from each other, should not be within the same business. So that's the first thing. Once you have that off to the side, then you're looking at your long-term assets. I usually like to break it up into segments. And by segments, I mean, if you have something that's a little more boring or stable, if you have like rental condos, if you have rental single family homes, I'll usually pool those together in one LLC. I think that's fine. I think if you get up to maybe, depending on your price point, if you get up to maybe like 10 houses, then I would probably say, I think we need to start separating this stuff out. Maybe it's time to set up a new one. If you're doing multifamily, you start getting into, 12, 18, 36 unit properties. You really need to start thinking about maybe only putting 1 or 2 in each LLC. Or if you get to a point where you're really doing larger ones, maybe you really need to start thinking about just doing 1 LLC for each of those properties, because they'll carry a tremendous amount of risk. A lot of things can go wrong. Also, a lot of equity involved. You don't want to have a lot of your equity in play if something should go wrong. So, when you're doing those multifamily properties, commercial shopping centers, there could be a lot of equity in play. It also makes things a little simpler if you're trying to like refinance the loan on there, or trying to get a new loan on those properties. If you stack up too much on top of each other, it makes those refinances very difficult. And also, when you're doing like single family rentals or something like that, you want to, if you only have 1 or 2 single family rentals, those are notoriously difficult to refinance or get a new mortgage on them. I found in order to get a bank to really look at those and really, refinance their portfolio, you kind of need to have like 10 of those in there, and then they'll look at it. The banks have a hard time underwriting and putting loans on those smaller single family home rental portfolios. You kind of have to have it, a larger amount. If you have like $1 million plus in there, then they'll go, okay, now it's worth our time. But if you have, multifamily, if you have, 12, 16, 18 unit apartment buildings, those you can refinance very easily. So you can have those in individual LLCs, and those are easy to turn over. Those are easy to refinance, because you want to be able to refinance easily, because the idea is hopefully you're buying assets where you can make improvements to them, you can build up equity, and you want to be able to have the ability to easily pull that equity back out. You don't want to get stuck in a situation where you can't pull your equity out without selling it. You want to be able to keep assets and pull equity out. That's the ideal scenario here. So you want to find that balance of what are you comfortable with. But then part of that also is, and it's probably going to be next question, so I'm going to cut you off. Do you do regular LLCs or do you do a series LLC? For those that don't know, you can do different LLCs for each property or collections of properties. Or you can do what's called a series LLC. Not every state has this yet, so you have to see if your state has it. I think there's I think we're up to like a dozen or more that do it. It's growing every year. But a series LLC is you have one LLC at the top, you have a parent LLC, and then imagine you draw a line down and then you draw a line across and then you have the little lines going down. You have the little children LLC. So you have you have Bob LLC, then you have, we call them series A of Bob LLC, series B of Bob LLC, series C of Bob LLC. Each of those series is treated as a different LLC. So you can have one property in series A, you can have one property in series B, you can have one property in series C. Each of them are held separately from each other, and you can go as many series as you want. That's the advantage. It's a little more expensive to set up the series LLC, but then it's cheaper over the long run. So if you get to you have your 20th series LLC, you're paying a smaller amount of money to set each of those up, and then they're all connected with each other. Some people get a little nervous with the series LLC. It's still a relatively new thing. Now it's been around for a while, but it's still relatively new, so it hasn't been challenged in court a ton, which always makes people a little nervous. I think it's a secure way of doing it. Some people don't feel comfortable with it until it's really gone through the whole appellate court and it's been confirmed that this is acceptable, because not everyone's on board with it yet. I think it's fine. I like it, but if you really want to be safe, I have some people who say, I'm not comfortable with this whole series thing, I want to do regular ones. I don't mind setting up the series. My one caveat with that is sometimes people will set up the series and only have one bank account. I'd really prefer if you have separate bank accounts. So if you really want to hold these LLCs as separate entities, I would really prefer if you kept separate accounting. The only part that makes me nervous with the series is when people tell me they set it up and they have all these series set up for all these individual properties, and then they just have one checking account where they're throwing all the money in together. There's something called piercing the corporate veil. Piercing the corporate veil means you go to a judge and you say, look, this isn't a real LLC. This whole thing's a sham. It wasn't set up properly. They're really not operating as an LLC, so I should be able to go after this person personally. One of the tests that we use is, are funds being commingled? Meaning, are you swapping personal money with all the different LLCs together and you're not really holding it separate? So I would feel more comfortable if you keep all of your bookkeeping separate for all of your different properties. Realize it's a little bit of a pain, but we're talking about asset protection being on the safe side. The safe side is to have separate books for all of your properties to show that you're operating them individually.
Thank you, Bob. Do you? Oh, let me put it this way. Is California? Do they apply the series LLC? How about Texas? And just list a few states that apply that, because I know that in Illinois we do.
Illinois, we do. There's Illinois, Wisconsin. Let me pull it up here. I didn't have it in front of me, but I can pull it up very quickly here.
I think Delaware.
Let's see. Delaware, Nevada. Nevada's a very popular LLC state. Illinois, Iowa, Oklahoma, Tennessee, Texas, Utah. I think there's more than that. Hang on, let's see.
I think Delaware, they only charge $300 for one LLC. After that, everything is the same. Even serial.
Yeah, well, in Illinois, yeah, when you're doing them in Illinois, they charge more to set up the first one, but then each series after that, it's only like $100. I mean, it's really nominal going forward. Yeah. Which is why a lot of people.
Open a LLC in California. It's expensive, and everyone see everything.
I have never had anyone ask for an LLC in California. It's not a great state for doing it. That would probably be the last state I would set one up.
Right.
I would say my top My top three, obviously, I do it a lot in Illinois. I mean, Illinois is obvious. But after that, I get a ton of. Sorry, I'm trying to read as I'm talking. I'll stop. I get a ton of Nevada and I get a ton of Wyoming. I get a fair number of Delawares as well. Some people just want to have Delaware, just for the notoriety of being in Delaware. I'll be quite honest. Some people just love the idea of I have a company in Delaware. Um, I really like Wyoming. I think Wyoming is a fantastic state to set one up. They're cheaper. They're very easy to work with. They're very business friendly. Your ongoing expenses will be very low. So I personally, I've been doing LLCs in Wyoming for longer than I can remember. I think they're a great state. I think they're a great state. But Nevada's kind of bringing up the rear. Nevada's coming on strong. I think they've got enough information out there where they're like, hey guys, come to Nevada, come spend your money here. We're a good state too. So either of those three are great places to go.
For Delaware, it's good for a foreign single member LLC, right? Because I think that's the only place that they don't need a Social Security to get an EIN. Is that true?
Well, no. So the EIN is generated by the IRS. So the IRS is always going to want your EIN. So there's no way around the EIN. And actually, I think it was about maybe 3 years ago. It's getting a little hazy. You know, it's funny with COVID, it makes it kind of hazy trying to remember how long ago. Sometimes I'll say something was 3 years ago, and someone will say that was actually 5 years ago. There's like a time gap there. But a few years back, the IRS changed the rules because we used to be able to request an EIN through another LLC. So we would get like an EIN for your LLC, and then your LLC would be like the member of the next LLC. We used to do that a lot. We still do that quite a bit. Like your one member, your LLC is the member of the next LLC. So it kind of passes up through. And sometimes you do that for partnership reasons. Maybe you own your LLC and then you're going into a new investment with someone else. So you start another LLC and like your LLC is 50% owner of the new one, if that makes sense. So we used to be able to take the EIN for that LLC and apply for the EIN for the new LLC. The IRS closed that and they said, guys, this is way too confusing. We can't keep track of it, which means you can't keep track of it. So now a person's social security number has to be used for applying for any EIN number. So even if you have an LLC that owns another LLC that owns another LLC, you have to have an EIN to open up a bank account. And in order to get the EIN to open up their bank account, you have to have a living, breathing person's social security number to apply for that EIN. So the IRS is going to know who you are, but the public won't know. Just they have to know for tax purposes. But that's not public information.
My question is this is not for a person that reside in the U.S. I'm talking about a foreigner that don't have a social security number, that they have it's a single LLC under their name, but they will own asset in the state. So in order to get they don't have a social security. Is that possible?
It's possible. You have to do a couple different things in that scenario. If you're someone who's overseas, you don't have now. You're fine to do anything in the United States as long as you either have a social or a green card. But if you don't have either of those things, there's a few extra steps you have to go through. You have to get the I-10. I always forget what I-10 stands for. Is that like international tax ID number? But you should get one of those. Individual taxpayer identification number. So if you're a foreign person, you can apply to get an I-10. If you don't want to do that, the other way of getting around it is you have to remember a lot of the things that we do is for taxation purposes. So when we have an LLC or a partnership or anything like that, that's what's called a pass-through entity. So pass-through means you don't have to pay taxes on the business. Everything falls to you personally. You file that on your personal income taxes. Obviously, if you're a foreign person, that becomes a problem because you're probably not, you could potentially try to get around paying personal income taxes. The IRS doesn't like that. So the way you could get around it is instead of doing an LLC, you can set up a corporation, and then it gets around that. Now, we don't like setting up corporations unless you really want to do one, because remember we talked about the LLC is a pass through. So all the profit automatically passes to you personally. So you only have to pay taxes once on your personal income tax. Pretty nice. When you have a corporation, when you have a C corp, you have to pay taxes twice, because you have to pay taxes on the profit of the business, then make a distribution to yourself, and then you have to pay your personal income taxes. Well, the IRS doesn't give you as much of a hard time because they know you're going to pay taxes on the profit of the corporation. So they know that they're getting at least one hit from you. So then it's a little more lenient whenever you're conducting business. So you don't have to do that, but it's one way around it. Usually people prefer to go the other route where they get set up, where they have that ITIN, and then they can, as a foreign person, can file whatever taxes they need to file in the United States. Either way, you're going to have to get it set up so that you can pay taxes. Anytime I've ever had an individual where they didn't want to do either, and just thought that they could ignore it, it always ended up being a problem down the road. So you can't ignore it completely.
Let me, because the thing is, this is from personal experience, right? I have an uncle that is in Vietnam. They actually opened an LLC here, and he didn't have a social security number, and he went with a company in Delaware. It's a registered agent there to do that, because I think Delaware you have to get a company there, because that's the business, the open LLCs, right?
You always have to have a registered agent in any state where you have an LLC. So that's kind of part. If you're going to do any LLC in a state where you don't reside, so if you reside in that state, you can just have it come to your house, your office, or whatever. If you don't reside in that state, you have to hire a registered agent. It doesn't cost very much; they're very nominal, but it's basically just a person with a mailbox that can receive.
Right. And they said that we don't need to provide them a social security number. They when they finish open the LLC first. Now they just send a SS4 in with IRS and get the EIN without social security number or ITIN number, whatever that they require.
Okay.
That's something that you familiar with? Just based on what you said, I thought that it's
yeah. I'd have to see what the way that they filled out the paperwork. They're probably just going about it a different way. Maybe they're submitting that paperwork first, and then the ITIN will get issued later. Sometimes people go about it. There's a way where you can kind of go about it a backwards way. So maybe they're doing something like that. But at some point, they're going to have a number so that they could file taxes.
Right. Anyone else have a question, or we go to? If we're not, we go to the list of the viewers' questions that we asked.
Okay, while waiting for the questions, I would like to invite whoever in Chicago, February 15th, come to our event, ARIA event. Bob Floss will be there, and he will stay for the whole day, right, Bob? Just kidding.
I will be there. You can ask me as many questions as you want.
Yes, it's gonna be 3 hours from 9 to 12. Breakfast will be served. So, and Bob will be here, and Bob and I will be the guest speaker at the event. So, February 15, Glenville, Illinois.
Để em nói tiếng Việt nha. Người nếu mà không gặp Bob với chị Daphne đó thì thứ 15 nha các bạn, tới Chicago, có đăng hỏi tới đó, hỏi lúc bữa đó là chỉ cần mua cho Bob một ly rượu thôi, khỏi cần tốn tiền nhiều để hỏi.
Ráng ngồi kế bên Bob nha, kiếm cái bạn
kế bên cần cái bạn để hỏi những cái chuyện mà về LLC Asset Protection. Là ngày 15 tháng 2 Chicago, chỗ nào chị Daphne?
Ở khách sạn Renaissance in Glenville. Glenville là north suburbs của Chicago.
Có gì mà mấy bạn cứ nhắn tin riêng cho chị Daphne hỏi cái chuyện đó.
Yeah, mình sẽ provide cái link để các bạn đăng ký nếu các bạn ở Chicago.
Hey Bob, I just said that if they go there, see you, to buy you drinks and mimosa in the morning, right? So if there's 10 people there, then you have to think.
You buy a drink, I'll answer any question you want. It could be about LLCs or anything. Just whatever you want to know.
Hope you doesn't get drunk by then.
Go drunk by now.
And Steven, you have a question?
Yeah, I have.
Go ahead.
Hi, Bob. I have a few questions.
Hey.
The first one, from my understanding, from the asset protection point of view, what do you think? Like, where should I open my LLC? Is it Wyoming is the good state, or I can open it in California? I live in California.
So it's a good question. So, whenever we talk about what state you want to open your LLC in, first you want to start out by making a list of what states do you already own properties in. So that's generally a good place to start. If you sometimes I'll have people come in and they'll say, "Look, I own a property in Illinois, but I also have one property in Tennessee, one property in Georgia, one property in Oklahoma. Where should I go?" And then you have to kind of decide what state makes the most sense. But generally, you probably want to start in a state where you already own a property. So that's a good place to start. Some states are obviously better than others, like we're saying. Delaware, Nevada, Wyoming are really good states to have an LLC in. Keep in mind though that if you decide to do like a Wyoming or a Nevada or whatever, you're not totally escaping your state. What happens is you create your LLC in that other state, but then whatever states you own properties in, you have to file as a foreign LLC. Now, I know that sounds strange saying foreign when you have a United States LLC, but you have to remember an LLC is confined to the jurisdiction of the state where you formed it. So if you want that LLC to be recognized in any of the other 49 states, you have to file a document to acknowledge that your foreign LLC, foreign to that state, is going to conduct business within that state. So you file, it's just a simple form that you file. There's an additional filing fee you still have to pay to your state. Now, some people try to do it to avoid any liability or minimize their taxes that are owed to that particular state, like a California, something like that. But you're not going to totally escape it. But you're going to have, because you have to file that form to be a operating LLC within the state of California. But hopefully you're minimizing the amount of taxes that you owe to California versus the primary residence of your business is in a state like a Wyoming or a Nevada where they have no state taxes. You don't have to worry about it. So you're trying to minimize it as much as possible. But it also helps to have your LLC, if you have 10 properties in Iowa, it would probably make sense to have your LLC in Iowa. But again, I have a lot of people that invest in Illinois that set up their LLC in Wyoming, and Wyoming's a great state to have your LLC set up as well. It's also the filing, the way you do the filing is different too. So some people like, one thing I like about, like Nevada, Wyoming, and those states, the way you file the LLC, it's incredibly difficult to figure out who owns the LLC. I mean, Wyoming in particular, when you file the LLC, if you try to search an LLC in Iowa, you're just like, I don't even know who owns this thing. It's just a name. So there's a lot of anonymity when you set it up in Wyoming as well that I like.
So let me summarize it in Vietnamese so the audience can understand that. Câu hỏi là vậy nè các bạn, là cái chuyện đầu tiên á, là mình mở cái LLC ở tiểu bang nào. Thì theo luật sư Bob á, thì mình mở cái LLC ở cái tiểu bang mà mình có công việc làm ăn hoặc có property ha. Nhưng mà mình vẫn có thể mở ở tiểu bang khác, rồi mình mở thêm một cái foreign entity ở cái tiểu bang đó, để mình go over một cái example ha. Giả sử bạn ở California đi, bạn có nhà ở Texas với Florida, thì một kiểu á, là bạn mở một cái LLC ở Florida, ở Texas, rồi làm luôn, không có thay đổi gì hết. Hai á, là mình mở ở Wyoming hoặc tiểu bang khác được, rồi mình foreign entity mở thêm một cái LLC nữa là foreign entity ở Texas and Florida để làm ăn. Như tại sao mình mở ở Wyoming, một cái chiêu rất đặc biệt của Wyoming á, là khi mở xong á, là mình có thể remove tên mình luôn, thành ra không ai biết, rất khó biết là cái LLC là của ai. Cái đó là một cái kỹ thuật để làm cho tên mình không có trên những cái tài sản, để đỡ gây sự chú ý ha. Cái đó là mình tóm tắt của cái luật sư Bob. Okay, thanks a lot, Bob. And second question. So right now, assume that I have a LLC, and assume that I can transfer the title of the property to the LLC. And if, first of all, I have a property in California, if something bad happened and the property managed by the PM, so who responsible for that liability? Is it the LLC or the PM, or which one?
Oh, well, I mean, it depends on what went wrong. So, well, a lot's going to depend on the management agreement you have with your property manager. So whatever the contract is, I find that a lot of people either don't have a contract or have a very minimal contract. So you would want to have it clear about whose responsibility is for what activities. If something should go wrong with the property, your property, with you and your property manager. I'll be honest, a lot of times property managers will, if anything goes wrong, will say it's not their responsibility. I have several, I'll be quite clear. I have several pending lawsuits with property managers right now for things that have gone wrong. And they said, well, that's not our fault. I don't know what you expect us to do about it. So choose your property managers carefully. I'll just leave it at that. It's choose your property manager carefully, because they can make or break your investment. They can lose a lot of money and then just walk away and accept no responsibility for it. So choose them carefully. Can you hold them responsible? It depends on what the scenario is. In this lawsuit, the investor was out of state. And I think I'd only seen each property maybe one time. This person had told him to buy these properties and, hey, I'll manage it for you. And had said that the units were rent ready and we're really sorry. They're just, for some reason, there's no interest in the properties, and sat empty for, over a year. And when my client finally fired the property manager, sent a new property manager in, the new property manager said, these aren't rent ready. They look terrible. They never turned these units over. And the previous property manager had charged thousands and thousands of dollars for rehabbing the unit that had never happened. So the unit sat empty for nothing. They were just taking money from this lady, and they were just managing them very poorly, taking advantage of the fact that she was out of state and wasn't actually going to visit the property. So you run into situations like that. Obviously we're holding them responsible for that. So we're suing them to try to, recoup the lost profits because they, lied to her as far as what the condition of the property was. Keep in mind too, some management contracts might have a arbitration provision, so you might have to go to arbitration for that. If something goes wrong as far as the tenants are involved, it gets a little murky as far as, what's the responsibility of you as the property owner, what's the responsibility of the property manager. I would say you have to make a clear case for, whatever negligence or whatever went wrong was the property manager's responsibility. But it's not a perfect system. I found usually there's a gray area there. Is the property manager told you about something and maybe you didn't want to deal with it, so they go, well, I told them, so I don't know what you want me to do. I'm not going to spend money out of my own pocket. It's not my property. So you run into a lot of gray areas like that where there's a lot of going back and forth. And a lot of times too, I see property owners will just say, look, I know this person messed up. I'm just going to fire them and hire someone new. There's no point in pursuing this. You get a lot of those scenarios too. So the best thing I can tell you is just choose your property manager carefully. If you're currently in a scenario where a property manager did mess something up and you think you have a potential, you have to go after them for that money, you probably want to talk to a local counsel to find out what the local rules are. And local laws are to see what you can or can't do to pursue them. And if they're licensed, you can, file a licensing complaint against them, and that doesn't cost you anything. You could try to go at it that way. But it really depends on what the scenario is and what it's very fact intensive, as far as what happened and what your case may or not be.
But I have a question. So basically, people usually this is that open an LLC for different state. Is there a purpose also to deter from suing? Because when they in a contract with somebody, they said if they're suing with that LLC, then it's gonna be in that like Wyoming state court or Delaware court instead. That go into more cost to
So that's a
taxpayer.
common misconception. So you're going to want to make sure whatever court you sue in, there is actually two aspects of that. First, you want to make sure whatever court you're filing a lawsuit in has jurisdiction. So jurisdiction comes down to a couple different things. One is, where's the plaintiff located? Number two is, where's the defendant located? Number three, where was the cause of action? Where did the event occur that triggered this lawsuit? So you're looking at all three of those things and you're balancing that out. So sometimes if you have if I have a plaintiff that's in another county, or another state or another county, but I have a defendant and the property where the incident occurred are in the same place, well, that's where we're going to file. We're going to file there. Now, what you're talking about is sometimes you can contract, so you can have a contractual agreement with someone that if any dispute should occur between these two properties, it has to occur in X jurisdiction. And that's really how Delaware became very, very popular. Delaware is notoriously on the side of corporations, protecting corporations. So really big businesses, huge corporations that you would do business with, usually all have some sort of thing. When you click on pretty much anything now, and they say, "Oh, you have to scroll through the terms of service," and you go, "I don't have time to read all this," and you just scroll as fast as possible to get to the bottom. Somewhere in there, we'll probably say if there's a dispute, you have to submit to Florida or Delaware or something. You have to file suit in one of those states, because a couple of things. They want to put the burden on you to come to them where they're located at. And also, there are different counties. There's different states, and there's different counties within states that are notorious for leaning one way or the other. There's Delaware is notorious for being on the side of corporations. If you have to sue a business and you have to go to Delaware, you have a huge mountain to climb. It's just, everyone knows it. There's one county, it's totally escaping me now, I'm drawing a blank. There's one county in downstate Illinois where attorneys will go to file big personal injury or class action lawsuits, because that county is notorious for being lenient towards allowing class action lawsuits to go forward. So people go down there just to file it. People will venue hop to try to get the best court, the best judge that they can get. But remember, you're limited to, the contract has to state that the parties agreed that you have to be in that county to file suit. If that's not contractually agreed upon, then you're going back to the test of, where's the plaintiff, where's the defendant, where's the venue, or where did the act occur. So if your LLC is in Wyoming and something goes wrong with your property in Nebraska, and the defendant, the person you're suing, or let's say you're the defendant, the plaintiff who's suing you is also in Nebraska, they're probably going to want to file in Nebraska, and they're going to say to the court, "Look, I know this LLC is technically in Wyoming, but they filed as a business that operates in the state of Nebraska. We're all in Nebraska. The incident happened in Nebraska, so we're doing it here." And the court will probably agree, unless you have something in a contract that says otherwise. So just because you're in a foreign state doesn't mean you automatically have to have your litigation in that state.
What do you think about the mutable label LLC? It means that, assume that I have a one LLC called LLC number one, and unmutable small LLC. What do you think about that approach? Is it better, or is it worse from the access protection point of view?
He meant series, right? And Stephen, you meant series LLC?
I think series on LLC only work for Texas, but assume that Florida or California. Do you think that, for example, I have a one LLC, that's my main LLC, and depend on who I work with, I open another LLC. and I use that LLC to partnership with the other party, and my main LLC will own a portion of the partnership LLC. Got called it that way.
I'll tell you what. There's ways of refining and perfecting the process to make it
Yeah.
the maximum asset protection, or sometimes the balancing test is to make it easier for you and your bookkeeping. Because I know sometimes when we try to do this, sometimes it can make bookkeeping a little bit of a nightmare. And I acknowledge that we try to balance those two things with each other.
Every
That aside, as long as you're putting your assets in an LLC, you're fine. I mean, it's really up to you how you want to do this. I have clients that put everything in series LLC. They want it that way. I have clients that want everything in individual LLCs. That's the way they want it. There's not really a right or wrong involved with this. It's really what your personal preference and how you want to set it up. As long as you're properly setting up the LLC, you're fine. The bigger thing I'm concerned about is I want to make sure that if you're doing these LLCs yourself, now obviously I would prefer to do them. But if you're going to do this yourself, not excited about that. But I realize, some people, want to try to do this. Number one, you're going to file the articles with your, whatever state you're going to form it in. That part you could probably figure out how to do on your own. Sometimes I prefer to do those, but a layperson can navigate that, can figure it out. The harder part is, well, number one, number two is you have to get your EIN so you can set up the bank account for that business. You want to do that. And then number three is you want to set up a good operating agreement. An operating agreement, depending on the business, depending on the partnership, depending on what's going on, can be very simple. It could be, I've seen people pull one off of Google and, they're terrible.
no,
They're, 10 pages long, don't say anything. For some of you that have done LLCs before, mine have gotten quite lengthy over the years because every time something happens, I'm like, oh, that's good. I need to add that. So I add something in there. It's a book. I mean, it's gotten quite long. I don't feel like half my clients read it anymore because they're like, I don't even have time to go through all this. I'm like, it's all, everything you need's in there. It's long because ideally you want your operating agreement to tell you everything you need to know about the operations of the business. And I'll be quite honest, probably the first eight or 9 pages are the operations of the business. And then there's probably 20 pages, 25 pages of everything that can go wrong, because that's what you want the operating agreement to tell you. The operating agreement, if everything is going great with the business, everyone's agreeing with each other, arguably you may not even need an operating agreement. The reason you really need the operating agreement, for one, to set up your business properly, but number two, so that you have a framework when things go sideways. I can't emphasize that enough for people. So few businesses either complete from beginning to end or, complete a partnership without having some moment where there's maybe someone forgot something, or there's a disagreement, or, hey, I thought you said we were going to do this, and now you're doing that. I'm not really happy about that because that's not really what I thought we agreed to. Or maybe everyone just forgot what the deal was supposed to be. It's been years and everyone forgot. How did we just say we were going to split this up? I don't remember. The operating agreement is a roadmap of, hey, what are we supposed to do in this scenario? This person's unhappy or this person doesn't know what to do. Okay, in paragraph 35, this is what I said we were going to do. Bop, 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 bop. And it's like, okay, all right, so that's what we're going to do. Of how to handle every problem I could think of that could possibly come up with your business down the road. So you want that. Going back to the first point, though, you want to set up your business properly. We talked earlier about piercing that corporate veil, and the possibility of someone coming in and saying, look, I should be able to sue this person and get after their personal assets because they didn't really set up this business properly. They didn't finish yet.
Yeah.
Part of that is the articles, having a bank account where you keep track of your individual books for that company, but also having a full operating agreement. I'm not crazy about businesses not having an operating agreement. Even if you're the only member, it's just you should still have an operating agreement because it fully creates the LLC where it's a living, breathing entity. You have a document that says exactly how that business is run. And also keep in mind, if you have that operating agreement where it says exactly how the business is run, if something should happen to you, someone can go to that document and know how the business is supposed to be run. There's horror stories that I could tell you of someone passing away, and no one had put in writing how things were supposed to be split amongst partners, about what the deal was, about what the deal structure was supposed to be, and it made things very difficult. It made things very, very difficult because you're dealing with one person who's with us, and I'll be honest, you have to kind of weigh with the information they're giving you of, well, are they giving me the honest opinion about what the deal structure is, or are they kind of taking advantage of now the other person's gone, maybe changing up some of the terms a little bit? We want everything in writing. So I want everyone to have a full operating agreement of, especially for partners, as far as how everything is being broken down.
Thanks a lot, Bob. I think basically we need to back to the basic, set up correctly. Don't forget the basic. Start with the basic first, and don't do anything in advance. Otherwise, if you have LLC but it doesn't protect you, that's the miss of the thing.
Yeah. How you set that up is entirely up to you. How you set it. It does make sense to have individual LLCs if you plan on doing a lot of different partnership deals with different people. So when you set up that series LLC, it's usually one framework for acquiring properties. So you have like one company, you're going to keep acquiring properties. If you think you're going to be doing deals where you're going to constantly be bringing in different people in on your deal, you're going to be bringing in a different partner, you're going to be bringing in different family members for different properties. In that situation, it may make more sense to set up different LLCs because you're going to be dealing with different partnership structures, and it's easier to do that in a new LLC versus trying to change the series LLC.
I have only one question, and I think this is maybe take a lot of time to answer, so you can quickly give me a short answer if possible, and then we use the forum so then Thắng can ask for all the questions. I see many, not many, I see a few advertised about the private trust, but I feel it, in my opinion, of course, my understanding is very limited. I think the private trust is costly, and it does not work as advertised. They say all the good thing about private trust, but never say any bad thing about that. It's a little bit weird. Like say that you don't need to pay tax. It's protect you. I'm not sure that I using the right term or not. Private trust. But what is your opinion about that in the big picture point?
I don't know if I'm understanding. You're saying it's an apartment trust?
No, private. You are on muted.
A private trust. A private trust.
Oh, private trust. Okay. Sorry, that is it. A private trust. I'm trying to think of, because everyone calls things different, uses different terminologies. Yeah. I'm trying to think of what structure they'll be using to call it a private trust. I'll be honest, I'm not quite sure. Legal terminology, there's a revocable trust and there's an irrevocable trust. I don't know what they would be meaning. I'm trying to think of how they would be thinking of private trust, or what they would be using the terminology called a private trust. There is an irrevocable trust, which is permanent, and then there's a revocable trust, which is not permanent. The names kind of dictate that.
What Steven is referring to is all the insurance company,
not insurance company. I think they suggest that they have a irrevocable trust and transfer the access over there and don't pay tax on that kind of complex scheme. But I feel very weird, and I don't think that's correct. But I'm not in the position that I can give the right or wrong answer.
Yeah, well, so I'll go through the long version of that, which is the revocable trust is again an estate planning tool that you use that really doesn't become permanent until the moment that you pass. So when you do an revocable trust, you can change it at any time. You put your assets in there, but you can back it out. You can undo it at any point until you pass. Then once you pass, it becomes permanent. An irrevocable trust means it's permanent. You can't change it at any time. It's now almost like an LLC in a way where it becomes a living, breathing entity. The mix there is this really all comes down to taxation. When you're talking about weighing those two trusts against each other, absolutely the only reason you do one versus the other comes down to taxes. So at the moment when you do the revocable one, it does become permanent until you pass and you pay all the taxes with part of your estate through the probate. When you do the irrevocable, it becomes permanent, but because it's permanent, when you transfer any of your assets, any of your belongings into that trust, you pay the taxes at the moment you place it into that trust. So now you're paying the taxes like a gift tax. Now, right now, you're paying it this year. The reason you would want to do that is by paying the taxes now, it becomes a permanent thing within that trust, and it just keeps going on really forever. So when you have really wealthy families, they may take some assets, they may take the ownership in a company, um, an NFL team, something like that, that's only going to keep going up in value. They're going to take the hit now to put it into, their family trust and pay the taxes on it, because maybe the asset today is worth $100 million and they're going to have to take a huge tax hit and pay that tax now. But they're doing that because they know, look, 20 years from now, this is going to be worth $1 billion. So we'd rather pay the taxes now than wait down the line when it's going to be way more money. So we're just going to go ahead and do that. And now the family trust owns this asset. Really, it can go on almost forever. We have family trusts that are, hundreds of years old because, well, probably 100 years old, because they were set up, maybe back in like the 1930s, 1940s, and they're still in operation today. So the trust can really go on forever. Your kids can become the trustees of that trust and just collect, a check from the trust every year. And the asset just keeps rolling on, paying, dividends really to your kids. So that's why you want to do that kind of trust. When you're talking about this private trust, I almost feel like they're kind of overlapping several different things. So a trust would not have to pay. I'm trying to think of why they're saying the trust would not pay taxes. Are they talking about how it's a irrevocable and they've already set it up where there's not going to be a taxable event because they already own the asset? But if they already own the asset, I don't know why they're trying to bring in new investors on that. Or are they talking about how the revocable trust isn't taxed until the moment that they pass, but that doesn't affect you as the investor at all. That affects the primary person. So I would have to know a lot more about that deal structure. It doesn't really make sense to me.
Yeah. So probably next time, and Stephen can provide more detail on that matter. And Bob, if you could, you did do another live stream to help the audience. But right now, I have one question for the audience and for us too. So, do you have any advice on how to choose the right attorney for our asset protection? Because we are all over 50 states. There probably some friends are in Vietnam, in Europe, in Australia. So, please advise.
All right. Well, if
do
whatever
you do it too? Do you provide service in other states or foreign investor as well?
Yeah, so we can set up. My office can help with LLCs. Like I said, I do a lot of LLCs in Wyoming, Delaware, Nevada. So we could set up an LLC in almost any state. So we can help you out with that. When it comes to litigation, you want to always have local counsel ready to go. So anything, if you have to do anything with your property in regards to an eviction, if someone sues you, building code violations, any things that come up when you own property, you want to make sure you know someone local to that property that can help you out. But as far as business formation, the asset protection, things like that, I can help out with any of that. That I don't have a hard time doing in any of the states. We're familiar with the different state laws. You just want to make sure that you do interview attorneys to make sure you have someone available if something should happen on a local basis. You want to have someone, ready to go. You want to have a name ready to go. You don't want to be panicking at the last minute. And you want to interview them. You want to find out about them, about their business, what their experience is. You want someone who's familiar with both real estate, with litigation. I would say the hard part is there's a lot of attorneys that do real estate that don't really have a lot of exposure to litigation. There's a lot of litigation attorneys that don't really have a lot of good exposure to real estate. So trying to find both of those can be a little tricky. Um, Anyone that does like evictions is usually a good place to start. They have trial experience, but they know some stuff about real estate. Someone like me is probably who you're looking for. Someone who really focuses on real estate, but all aspects of real estate. You want to probably the biggest mistake you don't want to get saddled up with, and I see this a lot. Someone who does real estate, but they only do transactional. I feel bad when I see other people where they have an attorney and they think that their attorney is going to take care of everything, but their attorney really only does like the real estate closing. Then if anything goes wrong, they say, "Oh, I can't help you with that." You don't want to have to keep finding new attorneys for everything. So ideally, you want to try and find someone who is capable of. Now, I don't do all kinds of litigation, but I do real estate focused litigation. So if it's something like the property manager, something goes wrong with the property, um, mechanics liens, things like that I will litigate myself. So you want to try to find someone who can do both. And that's not a tricky thing. And that's why you kind of want to interview people to make sure that they feel comfortable. You want to make sure that, obviously, do you have experience with real estate? Because I do see very talented litigators that try to do real estate closings, and I'll be honest, they kind of botch it because they're not really experienced with how to handle problems on a real estate level. Not that it's hard to understand real estate, but handling transactional is very different than handling litigation, and you have to be able to flip flop between those two mindsets. It's the mindset of the attorney, knowing how to handle transactional issues, where being very combative and fighting isn't really going to help the situation, versus when you're litigating, you do want to be combative and you do want to fight a little bit, and you have to be able to flip flop those two mindsets when I'm approaching a different case, when I'm approaching a different situation. So you want to ask attorneys like, hey, are you comfortable litigating, and do you have background in real estate? You want both of those things to help you out.
Thank you, Bob. So it's 10:45 right now. If you don't mind to stay a little bit to answer some questions, that would be wonderful. Dan have a lot of questions from the audience, and he will address.
Can I ask a question regarding the primary home? Because I know some people, they don't want to put their primary home under the LLC because they might lose the capital gain deduction, right? And California is different. They say it doesn't matter if you own a property under your name separately with your spouse or together with your spouse. When you get sued, you're still liable for that. So let me give you an example. Let's say husband and wife own a primary home, and then husband do business, and the chance of getting sued is high. So he sign a quitclaim deed, so he's not under the home anymore. And then later on he gets sued, and he liable with the judgment. Can the judgment attack the primary home? Because the home now is under the wife only.
Oh, well, so there's something called, if you own property, if you're married, you always want to own property as what's called tenants by the entirety. Tenants by the entirety is a form of ownership that's only for married couples. And that means that if something should happen to either, it means two things. If something should happen to either of you, the surviving spouse automatically becomes owner of the property. So you don't have to do anything. Second is, tenancy by the entirety has a credit protection on it, where, keep in mind, when you and a spouse purchase a piece of property, you both have to sign the mortgage. You can't really have a mortgage where, even if there's only one borrower, let's say one spouse has better credit than the other, and only one of you signs the note, the promissory note, they still make both of you sign the mortgage. Why? because unless the lien attaches to both of you, they can't take the house in a foreclosure, because tenancy by the entirety states if only one spouse has a creditor or has a problem with the creditor or judgment from a creditor, they can't take the house because it's a spousal property. So both of you have to be on there, which is why they make both of you sign the mortgage. So then both of you are on there together, even though only one's responsible for the debt. They can take the house if they have to foreclose on you. So if one of you has a judgment against you, gets in some trouble, if it's in tenancy by the entirety, the house is protected. Now, you still have other issues, but they can't take the house away from you.
Got it. Thank you, Bob.
Yeah.
You want to go over a couple of questions here we have on the chat, Dan? Or you have any other question? You're on mute. You mute.
In Facebook, there's a lot of questions. I think it's a good question. Could you bring that up to the screen?
Okay.
More of the question in the chat is we can answer later because I think Bob go over already. There's some questions in the Facebook because I don't want to waste Bob's time.
Okay.
No, I have time. I'm okay.
Okay. Actually, it's a very interesting question. I'm a tax pro, and I see people incorporating in Delaware left and right without incorporating in their own state as a foreign entity and file a tax return in their own state. By the time they come to me to file, can you address that and explain compliance for those who incorporate in their other states to bypass state tax by the state that they reside in?
Okay. I'm gonna answer that, but I'll start out by saying I'm not a tax attorney, so any individual tax questions I would defer to the person who asked this question. But what I can answer is, number one, it's your responsibility to file as a foreign LLC operating within that state. What I experience is, as an attorney, if you don't do that, if something should go wrong and you get sued within that state, and you're not filed to operate within that state, you could have some serious problems. So the example I've seen is you buy a piece of property. Let's say you have a Delaware LLC. You buy a piece of property in Illinois. You don't file for your Delaware LLC to operate within the state of Illinois. You just don't want to file. You don't want to deal with it. You don't know, whatever the reason may be. And let's say one of your tenants stops paying rent. So you go to file an eviction. Now, a good defense attorney could look and see you did not file to operate within the state of Illinois. Therefore, the state of Illinois courts are not open to you because they don't recognize you as a LLC operating in a different state. Therefore, the eviction should be dismissed because you don't operate within the state of Illinois and the courts are not open to you. I've seen that work. Now, you as the property owner can just file the document with the state and then refile the eviction. So it's not a catch-all. But keep in mind, if you don't file within the state to operate, the court of that state really is not available to you because they don't recognize you within that state. So that's the situation I've seen of, like, if you want to make sure you're protected in case a lawsuit should come up, they need to know who you are. Now, as far as taxation goes, that's a problem. I mean, that's a big problem. I found that me personally, I've had some dealings both with the IRS and I've had some dealings with Department of Revenue. Department of Revenue being the division of your state that collects funds for the state. IRS gets a really bad name. I find that the IRS is really pretty easy to work with. Department of Revenue is a whole different thing. Department of Revenue are not very nice people. So you do not want to owe money to the state. They are, in my opinion, way worse than the IRS. So you do not want to try to get by not paying any money you owe to an individual state. I think you're going to be in a world of hurt if you do that.
Yeah, especially California.
Yeah, California. Oh my God. For sure you don't want to get them on you.
Okay. All right, next question. I think most people here need some guidance and step process to protect their primary resident and rental property via the trust systems. Could you give us a layer approach to how to do it? First, living trust for real property. Second, family living trust, and the third, private and business trust.
Okay. there's a lot of thoughts in my head right now. I'm trying to organize them because there's a lot of things going through my head on how to answer that. You can have different trusts. You don't need to. You can just have one. There's really not any reason to layer out your trusts. Now, there's reason to layer your LLCs. There's not really a reason to layer your trusts. You can. I'm not saying you can't. I'm not saying there's never a reason to. Maybe you want to have some stuff go to some family members, and then maybe you want to have different assets in a different trust for different family members. So I could see where there'd be different scenarios for wanting to handle that. Maybe you're remarried and you want to have one trust for your first kids from your first marriage, and maybe you want to have a different trust for your kids for the second marriage. Just keep everything separated out. I guess I can kind of see that. Most of the time, you're just going to have one trust. So you're not really going to do a whole bunch of different trusts. Now, I'm talking about for estate planning purposes. This is your estate planning trust. That's the trust that's going to hold everything for if you should pass tomorrow, how your assets will be divvied up. I have had people do an individual trust for every property that they own. I don't know if it was 100% necessary, but I'm trying to think of how much information. It's tough as an attorney knowing how much information I could say or not say about my client's dealing. So I have to keep things sometimes intentionally vague, not to out anyone. So I do have some clients that, like when they rehab properties, God, how do I put this tactfully? All right. So they rehab, they flip properties, and maybe they're not always on the best of terms with all their contractors. I'll just leave it at that. So they don't necessarily want to keep using the same trust because they don't want maybe a partner that they had a bad dealing with or a contractor they owe money to see that trust pop up on another property. So for all of their flips, they do a different trust for every property. So it makes it pretty much impossible for the contractors to figure out what other properties they have actively going on for rehab and attach a mechanics lien to their other property. I'm not crazy about that, but and I'm this person's attorney, so I'm doing what I need to do to protect him, but I'm not necessarily thrilled about that scenario. But I mean that's why some people do things like that. You're trying to, maybe if you know that you do owe someone some money, you can set up just a whole slew of different trusts for everything you have to make really a shell game. At that point, when I say shell game, that when you see the guys that play the game where they have the 3 shells and they put the 1 ball over and they're moving the shells all over, you're basically setting up different trusts on everything to confuse everyone, that they can't figure out what properties you own or don't own. And then you can, do like your property flips or whatever you're trying to do without anyone knowing that you're doing that. So it's possible to do things like that. But as far as your rental properties, I mean, you should be able to just put it in, one trust, and then, it's done. And ideally your rental properties would still be a part of your family trust, the trust you have for your family members, because you want the rental properties you hold, you want them to go to your family. I mean, the idea is you're trying to set up all of this so that your family is set up for after you pass. So, I mean, you want them to be the owners of it. Ideally, what you would want is all those rental properties would be in an LLC, and then the membership of the LLC, instead of being in your name, would be in your family trust. Or if something should hit, you can keep it in your name for now. But if something should happen to you, then the ownership or the membership of the LLC would go to the family trust. So everything goes over there. So your family gets that property. So you want to remember, they're not separate. You want to overlap them.
All right. Can you discuss the responsibility to those who receive crypto or stock as rental income?
I feel like that's a whole different presentation.
Yeah, this is
Sorry, guys.
I'll skip this one. Skip this one to the next one. Okay. If rental property under a land trust, beneficiaries under a LLC, how about the trustee also under the same LLC or different LLC or the older name?
Boy, I need to read that again. Okay. So the rental property is under the land trust. The beneficiary of the land trust is the LLC. How about the trustee is also under the same LLC or different LLC? Oh, I think I know what they're trying to. So some people will break this out. So what they're really trying to ask for, I think I know what this person's trying to ask. There's a way of setting things up. Now we're getting a little more. What you're asking here is a little more complicated. This may be trying to kill a mosquito with a shotgun a little bit. This might be overkill, but when you start to deal with a lot bigger companies, we see this a lot with international trusts or international companies. So you may find and we're getting on a much bigger scale here. I mean, in order to do stuff like this, I'm about to talk about, we have to be talking, tens of millions of dollars, have to be crossing through these accounts to even make the headache of this worth your while. But the structure we're talking about with different states and different LLCs can play out on a global scale. So you can have, a land trust set up, either a land trust or a family trust set up like in the United States that's owned by an LLC, in Ireland that is owned by, another corporation or LLC or family trust that's in, I don't know, Australia or something like that. So people play the same game, but on a global stage. And what we found is people who play on that stage go one extra level, which is when you're setting up that trust, you take a step away as the trustee of the trust and you set up another LLC, and that another LLC's sole job and sole purpose is to be the trustee of the trust. Now, you or someone else or another company can be the sole owner of that LLC off to the side, but that LLC's sole job is to be the trustee of the trust. So you yourself are not the trustee. So they can't, the idea there is so that they can't like go after you personally as your responsibility as the trustee of the trust, that you're under another corporate shield as far as who's operating the trust. But I'll be quite honest, when you're dealing with things like that, it's usually because you're doing something, probably you're not supposed to be doing. So you want to create a shell game as far as who the trustee of the trust even is, so that everyone's trying to avoid the liability of maybe something they're paying taxes they're not supposed to pay, or they're dealing in something that might be illegal. And they're really trying to create a complete state of confusion as far as who's responsible or where the money's coming from or from what country the money is coming from. So that would almost be its own presentation talking about that, because that really, and I'll be honest, I don't know if I would necessarily advise that, because there's been a lot of notoriety about that the last few years, as far as that being a sort of a red flag for maybe some illegal activity. So I don't know if I would want you doing that just because people are watching that. So, I don't know if I want to advise you to go that route.
Some people say instead of getting an LLC, just get better insurance. Do you agree for some cases?
Oh my gosh. I'll tell you what, I, not as much lately as I would like to, because I've been pretty busy, but I do once in a while spend some time posting on a forum called Bigger Pockets. It's an investment website. It's really great. They have a chat feature on there, and the chat is very, very active, both good and bad. Sometimes there's a lot of bad advice on there. Sometimes there's a lot of good advice on there. I always feel like people who ask this question probably have been spending time on Bigger Pockets. I would really like to know if the person who asked this question has been on Bigger Pockets, because they, for sure, this is like their bread and butter. If you go in the chats, everyone's always screaming, just do insurance, forget the LLCs are a scam. Just do a, an umbrella insurance policy on all your properties. That's all you need. And I'm always like, oh, so do you guys stop it, please? So the ideology here is if you take out one massive umbrella policy, so an umbrella policy is in a massive insurance policy you take that just covers everything that you have. So instead of having to get out insurance on each individual property, you take out a huge umbrella policy. You pay one fee for that. And then as you're buying and selling properties, you just add them and subtract them from the policy. And it really doesn't change it. It shouldn't change it too much unless you add a huge asset in there. So it's in the long run, if you're going to add a lot of assets, if you own a lot of assets, it's usually more cost effective to do the umbrella policy. But there's some people out there that have this ideology of, forget all this legal jargon, forget everything, forget these LLCs, forget the trust, just put everything in your name and just do one massive insurance policy and you're covered. Now, here's the attorney, here's me, where, I'm going to poke some holes in that. Very simply, I get the ideology, I get the reasoning behind it. And I think there's one huge blind spot there. And the huge blind spot is, I don't know about you guys, but I've had some dealings with insurance companies. If you think that the insurance company is not going to try to avoid paying a claim, if at all possible, you're out of your mind. The insurance companies, to some extent, are in the business of trying to deny claims. So you might be covered some of the time, but you're not going to be covered all of the time. And you're leaving yourself exposed if you run into one of those scenarios where, and I'll give you an example of scenarios that I've run into. I get people that try to go cheap and they tell the insurance company, hey, I bought a property. Are you sure that insurance policy that they knew that you were going to have this as an investment property and not as like a second home or vacation home or a primary residence? Did they know that you were going to be making improvements to the property? Are you aware that if you have an insurance policy on a property, they only cover the property and the fixtures in the property? So if you're doing a rehab and you get a load of hardwood delivered, or you get a load of tile delivered, or you get all the appliances delivered, and they're sitting in the garage, if someone breaks into that garage and they steal all the stuff out of the garage, that stuff has not been installed in the property yet. It's not a part of the property yet. So if you went cheap on your policy, they're not going to cover it because it hasn't been made a part of the property yet. It was sitting in the garage. It's personal property. I've seen people get denied for that before because they didn't tell their insurance guy that they were going to be rehabbing or flipping the property. There's 100 scenarios where if you don't tell your insurance person exactly what the property is, what you're going to intend to use the property for, they can sometimes go cheap. Well, I had an insurance guy explain this to me very simply many years ago. He said, look, every time that you tell me to go cheaper with the policy, I'm not shopping around. He goes, the way a cheap policy gets cheaper is we go into the policy and we start deleting things. We start removing coverage. That's how it gets cheaper. We're taking stuff out of the policy. So you're removing coverage. So you are potentially exposing yourself to liability by going too cheap with your insurance, and maybe it's not covering your situation. Does your insurance company know if you're doing an Airbnb? If something goes wrong, you didn't tell them you're doing an Airbnb. Are you 100% confident they're going to cover you? I'm not. They're going to look for an excuse to not cover you. So you have to explain that kind of stuff to them. So all of that, as you can see, I've had many dealings with this kind of stuff. So I don't trust that just having an insurance policy is going to cover you. Also, when you're dealing with something where maybe something catastrophic happens at a property where there's a fire, someone dies, maybe both, something very seriously goes wrong with the property. Maybe you buy an old property, and I had this. If you buy an old property where it doesn't meet code, but it's grandfathered in, but there's a fire, your tenant causes a fire, and now because there's a fire, now you have to fix the property. But in order to fix the property, now you have to bring it up to code, and the only way you can bring it up to code is you basically have to dismantle the entire property because you don't have the right stairway length or height, or something's wrong, and now you have to take the whole property apart or basically demo it to rebuild it to meet the code. That happens. So you're running into all those scenarios. you don't want to run into a situation where maybe you have $1 million policy, maybe something goes wrong and now you have to pay 3 million. Well, now you're capped at $1 million. Well, someone's going to have to come up with that other 2 million because of a wrongful death lawsuit or something like that. You need to consider all of those scenarios. So, me personally, the insurance guys not going to cut it.
Yeah. I want to add a few comments here. Here's I think there's the two things here. The first one, I believe that the small investor has a trouble to put the home in the AOC if that home still have the loan, because if you transfer the title to the AOC, we get hit with the due on sale clause. I think that's one of the problem. What do you think on that, Bob?
That's a risk. I think I talked to you. Might have missed that. I think it was one of the first questions. That's a risk. So, if you what he's asking, in case anyone missed at the beginning, if you buy a property, and we get this a lot with new investors. So, if you're a new investor, probably your first couple properties, I've seen anywhere from 3 to 5 is usually the number of investment properties you buy. You may have to buy them in your personal name. You're using personal financing, maybe you're doing FHA financing to buy like a 2 flat, something like that. You're doing any variations of those things. So the property's in your personal name. There's a clause in the mortgage that says that the property has to stay in your name. If it doesn't, then you're automatically in default with the mortgage, and they can call the total amount due, aka a foreclosure. Now, I do get a lot of property owners that will maybe pay the mortgage for 6 months, maybe a year. Then we'll come in and say, hey, I want to transfer the property in the LLC. The thought process being there that once you pay for a while and you get a rapport going with the company, with the bank, they won't care as much. I usually tell people you for sure don't want to do it right away. Wait a little while, and then they probably won't pay any attention to it. But I always preface people with, technically you are now in violation of your mortgage by doing this. So you need to understand that. You need to understand that risk. Now, I've never had anyone have their note call due because they put it in an LLC, but I'm also very cautious and try to advise people away from it. I've had for a number of people do it. I've yet to have anyone come back and say that the mortgage company called them. Another way around that is putting it in the trust first. So if you put it in the trust, it's called the St. Germain Act. You're allowed to place any of your properties into a trust, and it doesn't violate the mortgage. So you can place it in their trust, and then that, the bank will see it's in the trust name, and then they won't do anything with that. So that's fine.
Yeah. But I think, in your opinion, that trust is a revocable trust, right? Or when you would
I almost every single trust we do is going to be a revocable trust. The irrevocable trusts are very, very few, very few. I mean, you have to be I'll be honest with you, you have to be both extremely wealthy and you need to have an extremely high value asset that you're placing into the trust to want to do that. And it has to be an asset. Keep in mind, if you're paying the taxes on it now, it has to be an asset that that your family is going to own 80 years from now. So there's a lot of scenarios that go into doing that.
But if you put in the revocable trust, I worry about it doesn't serve the asset protection purpose. Am I missing anything here?
So you can use it for asset protection purposes, yeah, but it's an estate planning tool. When you're doing anything with a trust, it's an estate planning tool first. The estate planning means the documents for the intention of transferring your estate if something should happen to you. If you die tomorrow, how's everything going to be dispersed? The trust handles that. It's not really intended to be for asset protection. It overlaps with asset protection because a lot of times we can use it, number one, to make it hard to locate your assets, but it also allows for the easy transfer of your rental properties, your portfolio, your LLCs to your estate so that your family can continue everything going forward. But the trust isn't an asset protection tool by itself. It usually has to overlap with other things.
But here's what I worry. I could be wrong. I'm not the expert. I believe that, correct me if I'm wrong here, if we transfer the access to the LLC, we have some kind of access protection. But if we transfer the access, my house, possible a rental, to a revocable trust, we don't have access protection. Am I wrong here, or am I
No,
missing anything?
that's correct. I mean, that's a risk that you play with that. So, well, there's two scenarios there. The first scenario is, like I said, wait a while, make payments for a while, and then people transfer in the LLC, but there is the risk there. The second is you put the property into a trust, and then the trust can be owned by the LLC, and the bank wouldn't know that. So you can have the LLC as the owner of the trust
Got it.
on the property. You can kind of do it reverse and
Yeah.
accomplish the
It
same
might
thing.
harder for the bank discover that.
Yeah, they're not going to notice. But like I said, I've had a lot of people put in the LLC, and I've never had it get called due yet. So, and, knock
Okay.
on wood. So,
And
as long as you're as long as you're paying your mortgage on time, that's all they care about.
Okay.
I want to clear I believe that the insurance and the LLC will serve different objective in my opinion. I think we should have both because the insurance will compensate you. Maybe they don't compensate you, but in theory, they compensate you for some kind of risk, some kind of liability. But the LLC will protect you from the risk of that house go to the other access. So I think that's the two different purposes. For example, if you buy a Airbnb house, you must add a clause to the insurance listing say that is a short-term rental and it will be covered. And we do it for many Airbnb house. And we also have a quick insurance to protect just in case some happen. That will compensate for the liability risk or maybe some property damage. But the LLC serve different purpose. They will make sure that if some liability happen, it doesn't spread to the other access. Am I missing
Yeah,
anything?
I mean, I guess I need to go back to earlier when we were talking about insurance. I'm not saying don't do insurance. I'm just saying don't only have insurance. You
Okay.
always want to have insurance on all of your properties for, I'm sorry if that was misconstrued at all. You absolutely need to have insurance on your property. I'm just saying I don't buy into the strategy of only having insurance.
Okay,
You
got it.
want to have an LLC, you want to have a trust. You still want insurance. You absolutely want to have insurance on your property. I would also emphasize if at all possible, when you're talking with your property managers or if you manage your properties yourself, that the tenant does not take possession of a unit until they show you that they have a certificate of insurance for themselves. So I have had scenarios where a tenant caused significant damage to a building, flicking a cigarette, something like that. There was a fire. And it turned out that the tenant never got their insurance. So the insurance had to be claimed on the owner's policy. If at all possible, you want it to be on the other person's policy. So, before your tenants move in, make sure that they have insurance. And I'll tell you right now, if you don't make them get the insurance before they move in, they're not doing it after they move in because they're just not. So you have to get them to do it before they take possession.
Okay. Thanks a lot, Bob.
Okay,
I'm, I'm
let's
done with
end.
my elaboration. Go ahead, Bill. Go ahead.
Then we have one last questions for the land trust. They just let me finish it. Sorry for the confusion about the land trust and the trustee LLC. We did not mean to ask about foreign trust. We mean to ask if we have a few rental in Florida. If we transfer the rentals into LLC directly, it will trigger the transfer tax. To avoid this, people recommend to put this rental under land trust, then name the beneficiary of these LTs at an LLC. Then for trustee, they will use one dummy LLC in Wyoming. This same trustee can be used as trustee for all the land trusts. Is that the right or wrong? Is that right?
It again. I always, everyone has their own way of doing things, so I don't. I'm not always thrilled being put in the position of having to disagree because I like to be open to different ways of approaching things. I don't really see what the need is for the dummy LLC as the trustee. I don't really see what the purpose of what you're trying to accomplish there is. I just don't see what the purpose is of it. Everything else up until that point sounds fine. Putting it into you could transfer the properties in LLC directly. I'm not sure about the transfer tax part. I don't know if that's you're triggering a transfer like a state tax, but any transfer tax generally is exempt when you're transferring it from yourself into your entity. So when we transfer, like if you own a property in Illinois, and I can't speak to Florida, but generally whenever I'm doing anything for my clients in any state, really, if I set up an LLC and I deed their property from their personal name into their LLC, there's generally an exempt transfer. There shouldn't be any transfer taxes owed on that. Sometimes there'll be like a nominal fee, like $25, but there shouldn't be anything serious involved with that. So that's the first thing. But I still don't see what the purpose is of, and doing the LLC with the trust or doing a trust owned by the LLC. That's all fine. That's good. I just don't see what you're trying to. I guess I would just go back to the person that told you that and say, what's the purpose of the dummy LLC? I don't really see what the need of that is. Whoever the trustee, you can have a person, you can have a company, you can have whoever be the trustee, and accomplish the same thing. Yep. There's me.
So that's the last questions we have today. If you guys have any more questions, please go to that website, forthlaw.com, and then you can, contact Bob directly. Thank you, Bob, very much to, join us today. And then you have anything to say? Conclusion?
Yeah. Well, thank you so much, Bob. If people want to see you, where can we see you, Bob?
You're gonna see me at the area event. Come out. I'm realizing, and now I'm thinking at the events in the morning. It's at 9. Probably don't come buy me a drink, but come out. Ask any questions. I'll be there. That's a little early. But come out. We'll be there. February 15th. It's at Renaissance in Glenview, right? Hey, Glenview is great, guys. I live in Glenview. It's a great town. You want to come up here? It's beautiful. There's a lot of stuff going on. There's a lot of good restaurants. So come out to Glenview. I promise you're going to love it. Plenty of parking. You're going to learn a ton. I'm going to be there. You can bug me. I'll hang out. I'll answer any questions you want. It's going to be a really good time.
Nice.
Perfect.
Perfect.
Thank you so much, Bob.
Yeah, thanks for having me.
Các bạn, mình trở lại, mình sẽ cùng với chị Daphne và mình sẽ translate, mình dịch lại từ nãy giờ, mình tóm tắt lại những từ gì nãy giờ câu chuyện nói qua tiếng Việt nha. Mình hiểu các bạn từ nãy tiếng Mỹ không, có thể các bạn nhiều cô chú không hiểu, thì mình tóm tắt lại. Giờ mình sẽ đọc những câu hỏi lại luôn và trả lời theo những gì mà anh Bob hỏi từ nãy giờ. Well, thank you so much, Bob. I don't want to waste your time anymore. Thank you so much for joining us this morning.
It's always a pleasure talking to you.
All right.
Thanks, Bob.
Thank you. Take care.
Bye.
All right. Bye, Bob.
Ok. Rồi, các con mình nói tiếng Việt là thoải mái rồi. Rồi, ok, giờ mình Thắng ơi, cái bên của Thắng nó làm gì mà ồn ào lắm á Thắng. Ăn uống rồi tứ tung á, cái microphone của Thắng ồn lắm.
Có cà phê ở chứ ăn đâu ăn.
Lúc mà tại vì cái microphone Thắng để vô nó gần á, lúc mà chạ gì nó nghe hết trơn à.
Vậy hả?
Cái này là còn livestream không nên? Cái này livestream.
Lúc mà livestream á, tại lúc mà Thắng đeo vô cái headset rồi.
Là không, giờ bữa phải qua lấy cái gì Blue Yeti của anh á, em về.
Lá kinh vô văn phòng kìa.
Luật sư có podcast chuyên nghiệp hả? Chơi microphone.
Yeah.
Đó.
Tại vì Hy lớn lên trong một gia đình trong real estate đó, Hy lớn lên trong gia đình đó nên Hy hiểu real estate rất là rõ.
Êm, âm thanh thu êm.
Ok.
Mai mốt đề nghị mỗi thành viên lên podcast phải mua một cái micro để hút âm.
để mình tóm tắt chút xíu lại từ nãy gì những gì anh Bob nói, rồi cái gì em có quên gì thì chị Daphne với anh Steven thêm vào ha. Từ nãy giờ là anh Bob cũng trả lời mình khá nhiều về LC. Thì LC là một hình thức mà mình giữ protect mình trong công ty. Anh recommend là mọi người ideally là phải có, nếu có tài sản nên để trong một cái công ty, cái LC. Một cái trust là khác, cái trust là để giữ tài sản, cũng như một di chúc vậy đó, cách để lại nhưng mà nó không hoàn toàn protect mình giống như một cái LC. Thường là người ta sẽ có cái trust sẽ own cái LC, giống hình thức giống vậy. Thì bạn có thể set up theo kiểu nào là tùy nói chuyện với luật sư của bạn theo từ trường hợp khác nhau. LC thì bạn có thể mở được ở tiểu bang khác nhau, mà 3 tiểu bang mà popular giờ nhất á, là Delaware, Wyoming và Nevada. Tại vì thứ nhất á, là những cái tiểu bang đó nó protect mình business nhiều hơn, nó giấu tên khó tìm ra, và nó có chi phí rẻ hơn để mở. Đặc biệt là những như là cái series LC theo Dan biết á, là mấy bạn có thể mở Delaware mà tính chỉ có $300 một cái LC tránh thôi, còn bao nhiêu cái kia là nó không có tính nữa. Đa số là rẻ. Thì anh Bob có nói thẳng về series LC thì ảnh thấy không có lý do gì mà ảnh cũng làm ở đó, nghĩa là một cái LC là nó làm cho một căn nhà như bạn ở Cali đó, nhà bạn khá mắc đó, thì bạn có thể LCA là một cái căn nhà, tại nhà 1 triệu lần chứ một căn là 1 triệu rồi, thì bạn có 1 triệu đâu đó vô trong một cái căn nhà, xong rồi bảo cái ngày thứ 2 thứ 3 thì từ cái A đó có một cái B, C, D, mỗi cái có thể là một căn nhà khác nhau, hoặc là 3 căn nhà, 4 căn nhà, là tùy theo cái risk reward của bạn, theo tính theo cái strategy của bạn mỗi là khác. Tại vì mỗi căn LC nó càng mắc, là mắc tại sao? Không phải là chi phí LC không nữa, mà khai thuế bạn rất mắc. Không thường đâu, thường khai thuế của đen là chóng mặt lắm, có nhiều LC quá rồi, là cứ mỗi cái LC mà rẻ Việt Nam nó chặt một CP Việt Nam chặt 1.000 là một cái thôi, là cũng bao nhiêu bạn có 7 cái là bạn là 7.000 rồi. Thứ hai nữa là nếu mà bạn làm LC khác nhau á, là làm ơn là đừng có mix cái personal use vô trong cái LC. Tại vì lúc mà bạn dùng tài chánh mà personal và LC lẫn lộn nhau, thì lúc mà ra tòa có thể nói là bạn không có dùng này đúng với hình thức LLC, thì có thể là bạn sẽ mất cái protection của LLC. Và nếu mà bạn có LCA và B, hai cái dùng tiền lẫn lộn nhau, không có hai cái băng checking account riêng, thì nếu mà hai cái mà không có riêng vậy đó thì lúc mà tòa ra, luật sư nó thể kéo lại, nó nói là bạn dùng chỉ một LC thôi, hay là bạn không làm đúng theo cái trường hợp của LC. Tại bởi vì nếu mà mở LC thì bạn phải giữ accounting và giữ làm theo cái compliance của LC thì mới được protection 100% về liability. Là liability protection là sao? Có nghĩa là bạn có một tài sản trong LCA, là bạn đang muốn mua cái nhà đó 1 triệu đồng, bạn có 200.000 ngắt cái đi, 80% là mượn loan. Lỡ chuyện gì xưa kiện trong LC đó thì người ta maximum á, người ta lấy được á, là 200.000 của bạn không thôi. Còn mấy tài sản ở ngoài bạn á, thì không có bị đụng tới, nếu bạn set up đúng và comply với cái luật của LLC. Nhớ nha, nếu mà set up đúng nha, cần với comply với luật LLC là rất là quan trọng. Tại vì mình biết là nhiều người có LLC lắm, nhưng mà nhiều người dùng tiền lộn xăng ngầu, thì lúc đó thì hay là không có được comply đúng giấy tờ, không có file đúng ngày, hay là những cái statement information, cái for entity là không có đầy đủ thì nó không comply nữa. Là nếu mà bạn có LLC mà Wyoming hay là ở tiểu bang khác như Delaware, thì nên không phải nên, bắt buộc luôn, nếu bạn làm gì có Cali thì bạn phải file lên một tờ giấy tờ nữa là for entity, là một công ty tiểu bang khác làm ở công ty Cali, làm ở Cali thì hay là làm ở Texas gì đó, thì bạn có file cái đó, thì mấy cái chuyện đó nó comply đúng với luật của LLC. Đó là tóm tắt lại những gì mà nói. Còn những chuyện khác là tranh cãi giữa cách setup làm sao cho khó thưa kiện hay là khó chạy trốn đó, thì các bạn phải nói riêng với luật sư của mình. Tại vì một luật sư không thể nói chung chung được tất cả hết, người ta chỉ nói trong protection của LLC thế nào và tại sao. Thì theo mình nói, theo những gì anh đã nói, thì tất cả các bạn phải có LLC hết nếu mà ôn tài sản. Một lần thứ hai nữa là luật nhà băng, nhà mortgage, muôn nợ, nó không thích bạn, không phải thích nữa, mà nó sẽ có luật đó, giữa hợp đồng giữa bạn và nhà băng lúc mượn loan, nó không muốn bạn cái tên nó ở under LLC. Thì nếu nó biết ra bạn ở LLC thì nó có quyền send một cái notice ra, nói là bạn phải trả tất cả tiền, giờ tôi không thích bạn nữa. Ok, bạn không được vậy, bạn đã violate một cái rule liền tất cả, mà mất luôn cái term. Có thể bạn là có lãi suất 3 chấm đi, nó ok, đền giờ phải làm lợi từ đâu. Thì thường có chuyện này xảy ra lúc mà lãi suất lên thì nhà băng nhiều khi nó trả lợi, nó muốn tăng lên cái đó, nhưng mà đang có thấy cái chuyện nó xảy ra. Nhưng mà cái chuyện nó cái chance, nó cơ hội rất là ít, rất là ít. Tại thường nhà băng á mà mình mượn loan với họ rồi và trả tiền đầy đủ thì nó không bao giờ coi là hồ sơ mình nữa, trừ khi mà nếu mà bạn không có trả trễ hay gì khác đó, thì cái đó là một cái rủi ro nếu bạn để tên ở dưới LLC, nếu mà bạn là người đứng ra bảo lãnh cái nợ đó. Ok, thì thường người ta mở LLC, người ta mở trong mượn loan theo kiểu corporate commercial loan hay gì khác rồi thì không có bị chuyện đó. Còn nếu bạn là người đứng tên, là bạn mới ra quá, tại thường LLC mà chưa có một cái track record, mới có mở trong chưa dưới 2 năm thì nhà băng nhiều khi không nói chuyện, bạn phải đứng cá nhân ra, thì những chuyện đó là bạn phải nghĩ tới. Nhưng mà đen thì đó là bạn phải nghĩ tới nha. Còn chuyện rủi ro làm hay không là chuyện của bạn. Tất cả những cái gì setup là rủi ro và reward là thì luật sư sẽ setup cho mình. Còn những chuyện cá nhân của mình là do mình quyết định đó. Cả chị Daphne với anh Steven có add gì không?
Để mà cho những bạn rất còn mới đó, hoặc là mới so với những cái chuyện mà đầu tư, những cái chuyện làm thành lập LLC, tức là công ty trách nhiệm hữu hạn, thì mình giải thích chút xíu rõ hơn. Tức là nếu mà mình để tài sản dưới tên của mình á, không những khi mà có chuyện gì xảy ra mình mất cái tài sản đó, nhưng họ có thể kiện và lấy những tài sản khác của mình, tức là lấy nhiều hơn là những cái tài sản. Ví dụ người ta bị chết, bị tai nạn hoặc bị một cái gì đó trong một cái building mà mình đang thuê đó, thì không những họ kiện ở trong phạm vi cái tài sản của cái building đó, mà họ kiện hết tất cả những gì mình sở hữu ở chỗ khác nữa. Mình cũng bị expose ra vậy. Và đó là để mình protect như vậy thì mình cần để cái property đó, cái rental property đó ở dưới một cái LLC, để mà nếu mất thì chỉ mất cái đó, không có vượt qua. Bởi vậy đó là cái mục đích của asset protection, bảo vệ cho mình. Thì Dung chỉ muốn clarify rõ lại cho mọi người như vậy. Và cái việc chuyển từ tên của mình đi qua một cái LLC như Dan nói thì nó có cái rủi ro, tức là có thể xảy ra và có thể không xảy ra đó. Thì như Bob nói, thì theo Bob biết thì trước bây giờ người ta đổi thì chưa thấy trường hợp nào bị nhà băng bắt phải lấy lại số nợ mà họ cho vay, chưa thấy. Nhưng có thể có xảy ra, right? Chứ không phải hoàn toàn được bảo vệ. Nên là việc chuyển qua đó phải cẩn thận. Và khi mà nếu mà cũng nên khuyến khích mọi người bắt đầu để tạo một cái LLC để sở hữu một cái property, một cái tài sản nào đó. Bởi vì mình dần mình build credit, lúc đầu mình khó khăn, nhưng sau đó thì mình bắt đầu thì mới có trưởng thành được. Cái nhà băng họ sẽ thấy mà mình là một nhà đầu tư và làm quen với những cái LLC, và cứ thế mình tiếp. Cái gì cũng có bước bắt đầu cả, nên là hãy tập làm quen. Và đặc biệt là nên kiếm một luật sư rất là uy tín ở vùng local của bạn thì càng tốt, phải chạy đến hỏi, hoặc có gì là cần phải hỏi. Và cái LLC thành lập ra đó chỉ là một chuyện thôi, rất là dễ, rất là nhanh. Nhưng mà cái chuyện những cái gì ở trong cái LLC đó operating agreement, tất cả những cái contract, những cái hợp đồng trong cái LLC đó, đặc biệt là mình làm chung với ai đó, thì những cái document đó phải viết do luật sư thiết kế, và phải làm cho nó đúng, cho nó tốt để bảo vệ các bạn. Thì nên là kiếm một luật sư uy tín để mà giúp cho các bạn. Mình xin hết.
Mình có cái opinion khác, không phải khác nhưng mà thêm vào thôi. Mình nghĩ cái LLC để dùng access protection đó là phòng tuyến cuối cùng, nghĩa là tới cuối cùng mới xài cái đó, chứ bình thường không có xài. Bình thường á, là theo quan điểm của mình á, là mình phải dùng insurance để protect. Ví dụ mình cho cái ví dụ, ví dụ như nhà Airbnb đi, bên mình là 4 layer protection, nghĩa qua được 4 cái layer đó mới tới LLC. Tại vì khi mà sử dụng tới LLC á, thực sự là mình đã tổn thất quá nhiều rồi. Mình chỉ coi như là mình gây up luôn cái access đó để đừng có lan vào access khác thôi. Mình nên làm, nhưng mà cái chuyện đầu tiên á, là mình phải protect, không phải để mất access mà protect access in the first place á. Là thành ra khi mình làm á, thì mình phải có, thứ nhất là bảo hiểm đàng hoàng, giống như Airbnb á, là phải có 4 layer bảo hiểm, chứ không làm một cái layer là xong á. Là 4 layer nên khả năng mà thua nó cực kỳ thấp, nó đánh qua tới 4 phòng tuyến, tới phòng tuyến thứ 5 mới tới LLC ha. Cái đó là chuyện thứ nhất. Thứ hai là trong cái quá trình vận hành cái access á, ví như mua nhà cho mướn construction là phải có bảo hiểm đàng hoàng để mình protect cái access trước đi. Rồi trước, tại vì LC là khi mà tính tới LC access protection á, là tới đường thua rồi, nghĩa là mình gave up access đó, mình buông luôn cái LC. Thì trước tiên là mình phải nghĩ tới cái bảo vệ, không phải là cái access protection á, là bảo vệ những cái access còn lại, chứ không phải là bảo vệ cái access mình đang bỏ trong cái LC. Thì mình ngừng lại đây để coi có chị Delphine Thắng hay Đen có cái opinion về cái đó không?
Cái này em không có opinion anh. Cái này là luật, rồi em có opinion, tức là tất cả là risk reward của một người mà quyết định riêng của kêu. Thì mình chỉ nói trong lĩnh vực là bảo hiểm là một cách protection asset của mình, LLC là một cái protection của mình. Mướn người có bảo hiểm như nãy anh Bob nói là property manager, cái hợp đồng giữa một người mướn và người property rất quan trọng. Bạn không nên nghĩ chỉ mướn furniture là tìm cho con số rẻ giá 5% gì thôi theo kiểu Việt Nam, mà sao lỡ chuyện xảy ra thì tất cả cái trách nhiệm nó lên mình bạn. Ok, bạn có thể chỉ làm chuyện đó, chuyện tốt, và bạn có bảo hiểm thì bạn có thể làm chuyện đó, mướn người rẻ 5%. Nhưng nếu không có những chuyện đó hay gì khác thì cái hợp đồng mà giữa người quản lý và người và nhà bạn rất là quan trọng. Tại vì chia ra cái liability của họ là gì, tại người quản lý, các bạn công ty quản lý sẽ có bảo hiểm riêng của họ, thì cái đó là rất là quan trọng đó, rất là quan trọng. Nên thấy là người Việt Nam mình thì thiếu sót cái phần đó. Lúc mà như anh Steven nói là không muốn contract thì phải có bảo hiểm, nhưng thường á người Việt Nam mình lúc mà mướn property manager hoặc contract thì không có care chuyện đó. Cái họ care đầu tiên nhất là giá cả. Thì mấy các bạn cứ suy nghĩ lại, một tài sản 1 triệu đồng có cần nên có giá cả chút xíu vậy không, mấy phần trăm không, để lúc mà lỡ chuyện ra thì nó khác. Thì bảo hiểm phải có là một, LC có là bắt buộc phải có. Tại vì nãy có nhiều người nói á, là nhiều khi mua bảo hiểm umbrella là 2 triệu 3 triệu đủ rồi, khỏi cần LC. LC là một chuyện khác, hai cái protection nó khác nhau. Cái bảo hiểm á, là những chuyện gì xảy ra trong property khác, còn LC là đúng cái thư kiện nó dính líu tới những chuyện nhiều khi mình không tưởng tượng được. Những là một người tenant chuẩn bị bệnh gì trong cái firewall, nó không mới gì tới bảo hiểm hết trơn đó, nhưng mà nó đụng chạm tới cái tài sản LC. Tại mỗi là phần layer của bảo hiểm hay là kia nó có cái protection khác nhau, và những cái phần quản lý á, thì bạn lại nó hoàn toàn có protection khác nhau. Nếu bạn mướn một người quản lý mà chịu trách nhiệm những chuyện gì như là cây cỏ, trim cây đồ, các garden ở trên đó, họ có cái library, lỡ chuyện gì đó thì người ta sẽ thưa cái property manager đó, chứ không thưa cá nhân của bạn hay là cái câu LC đó. Thì cái đó là cách deal, đó là một phần của một layer mà như Steven nói đó, là giữa bạn chọn đúng người. Thứ hai nữa mà layer thứ hai là bảo hiểm thì người nào té trên property mình là những chuyện gì mà đụng chạm có kia thì lửa cháy đồ, đó là những protection của mình hay BNB. Thì em nghĩ có người party hay làm gì khác nó phá thì cái đó là một cái. Còn nếu về LC nó hoàn toàn khác, bạn nó không mắc mớ gì tới cái kia, nó là một cái protection khác, là nó giữ tất cả asset trong một chỗ, cho dù bạn tệ cách mấy nó nằm trong một chỗ, có nghĩa là bạn mất như đó thôi, chứ không phải nó là kia. Nhưng trừ khi bạn là người điều hành LLC đó và bạn là người đã làm gian lận gì đó thì nó sẽ liên quan tới những, có thể là tấn công tới cái tài sản cá nhân hay những LLC khác mà bạn có bạn là chủ. Còn LLC nó chỉ làm được, nên thấy là theo nói chuyện với Bob, nó chỉ làm được hai thứ: giữ tất cả chỗ đó vô một cái chỗ, mà cũng như bạn có cái LCA nhà đó là A, thì tất cả lỡ thua kiện gì nằm trong A thôi, nó không qua B C D. Ok, còn trong đó bạn phải có bảo hiểm đối với furniture là chuyện riêng của bạn trong phần đó. Trong cái LC đó nó chỉ limit nằm ngay chỗ đó nếu bạn vận động đúng, vậy làm đúng. Bởi vậy như mà có nhiều người có nhiều cái LC khác nhau là tại vì người ta tùy theo. Có nhiều người chứ một căn nhà một LC, có nhiều người có tài sản 1.000 đồng 1 triệu là một LC, 3 triệu là mỗi cái triệu là một cái LC. Thường người ta tính theo giá tiền ở trong gì bạn willing để mất bao nhiêu thì tùy theo bạn. Có nhiều người làm biến đó, ok 3, 4, 5 căn nhà, 10 căn nhà cũng một LC đó, không chịu chia ra LC là cái rủi ro. Bạn sẽ thấy nếu mà 10 căn nhà trong một LC á, lỡ căn nhà nào mà bị thua kiện của một kia thì nó có thể tài sản lấn qua mấy cái nhà trong 10 căn đó, trong gồm trong LC đó. cái đó là tùy theo mỗi người, theo cái rủi ro của mọi người muốn take on thôi. Còn nhưng mà cái backdoor là gì, nếu mà bạn có nhiều LC là thuế rất nhiều, là có nhiều lúc mà khai thuế đó, giấy tờ đừng rất là mệt. Tại vì mỗi LC đó bạn phải nhớ là một cái bank account, một cái xài riêng hết đó. Cái mà lộn nhất của người Việt Nam mình là có thể 3 cái LC, mình khi có một cái bank account làm tứ tung trong một cái đó, thì cái đó giữ giấy bằng, nếu mà làm nhiều LC là giấy tờ rất là kỹ nha các bạn, rất là kỹ, để cho sau này mà lỡ mà nó bị thua kiện nó không có đem ra. Còn những cái chuyện mà mở LC chủ này tiểu bang này tiểu bang khác là tại vì những tiểu bang luật khác nó có cái luật protect giữ identity với thua kiện khó, hay là những cái tiểu bang mà nó có favor những cái công ty hơn, công ty sẽ thắng dễ hơn là người thua kiện, thì cái đó là bà phải hỏi luật sư riêng, chứ tụi mình đây chỉ tóm tắt là vậy thôi.
Mình đó thì mình muốn nói mọi người đó là LLC không phải là một cái magic solution, nhưng mà LLC đó là để limit cái liability thôi. Mấy bạn phải protect cái asset của bạn bằng thêm nữa, chứ không phải LLC không ha. Giống như là thí dụ như có rất nhiều người á có nhà cho mướn Airbnb, nhưng mà mở cái insurance coi không có một cái short term rental coverage, là cái đó là yếu rồi. Tại ép cái đó vô không có nhiêu tiền đó ha, thành ra không có chịu mua. Rồi thứ hai á là không có cái trip insurance luôn, nghĩa là khi mà khách vô nhà có phá hư hỏng gì á, mình đòi khách không được là mình phải móc tiền túi ra, hoặc cắt xù là cũng bó tay. Thành ra mấy bạn cần phải mua những cái bảo hiểm đó để trước tiên á là bảo vệ cái tài sản của mình, đỡ những cái rủi ro damage. Rồi second á thì cái LC á, là nó limit cái liability, là cái đó quan trọng. Nhưng mà giống như chị Delphine với lại đem lặp đi lặp lại rất nhiều lần là mở cái LC là phải vận hành cho đúng, giống như là phải có một cái EAN riêng nè, hoặc là Social Security riêng cũng được, có bank account riêng, cái operating agreement phải rõ ràng, và có một cái nữa là annual meeting á, meeting minutes at least á, là phải gặp một lần, viết xuống, viết theo nó là năm nay là mình sẽ kiếm được tiền, hay là có viết một cái meeting minutes và record xuống, mọi người ký tên vô, để cái đó mới là một cái separate entity, chứ không á là mình mở LLC nhưng mà cuối cùng nó cũng không có giúp được mình về cái mặt mà limit liability. Cái đó là back to the basic á, đừng có khoan nghĩ những cái chuyện lớn, cái chuyện căn bản, làm những cái căn bản, mở ra làm sao, làm như thế nào. Còn hồi nãy cái Dan nói về cái series LLC hay là parent and child á, thì mình nghĩ cái topic nó hơi complex chút xíu, tại vì tiểu bang Cali á thì theo mình hiểu á là nó không có series LLC unless I'm mistaken, nó chỉ có những tiểu bang ngoài giống như Texas là mình hiểu là có. Thì cái đó là cần phải hỏi lại luật sư để
cái này tại anh nãy anh miss anh Steven lúc đầu á có nói chuyện với luật sư cái này. Luật sư có mention là series LLC. Series LLC á, là luật sư có nói á, là tòa án á, appellate court á, thì nó ok, nhưng mà nhiều người lo sợ cái đó, có thể là anh Steven một trong người đó, là nó chưa confirm cho tòa án, mà Supreme Court nó chưa có làm. Thì đối với luật sư thì cái risk rủi ro thôi. Thì em nói series LLC thì để xem em research ở Delaware đó là làm dễ nhất, rẻ nhất trong những kia. Thì cứ thì thực ra cái đó là do tòa án thôi, nhưng mà người ta vẫn làm, tại vì khi nó dễ dàng cho người ta upgrade là rẻ. Còn cái chuyện mà mình có thích làm hay không là mọi người lúc đầu luật sư Bob có nói chuyện đó.
Mình không có nói là không làm, nhưng mình nói là confirm lại luật sư cho kỹ cái vấn đề đó. Mình không có dám nói không làm phải làm, mình không biết. Nhưng mà mình là cái người không có dạng, nên mình cần cái gì mình hỏi kỹ lại.
Cho em hỏi cái Steven, anh nói là mua 4 layer insurance á, thì không biết là total cái fee của 4 layer insurance đó nó chiếm bao nhiêu % trong cái rent? Tại vì em nghĩ nếu mà scale lớn lên cả chục căn á, thì mua, chứ ví dụ em làm gia đình 1-2 căn thì có nên mua không anh? Tại vì nó sẽ ăn vô cái phần chi phí nhiều quá.
Không,
nếu tính về risk reward
nó khá là thấp á, Thắng. Như Airbnb đi, bây giờ mình nói từng cái đi. Bây giờ thứ nhất á, là bảo hiểm cái trip insurance thì nó khoảng $10 một ngày,
là khoảng 300 tháng.
Không, khi là người ta ở mới có trả tiền, không ở không trả tiền.
Ok, vậy cũng được á, là theo khách.
Nó vô nó đập cái tivi của Thắng, mà Thắng có thể claim bảo hiểm thì nó deductible. hoặc là claim Airbnb lại thắng được hai cái nguồn tiền có thể dễ xoay sở ha. Cái đó là layer thứ nhất. Cái layer thứ hai á, là Thắng phải dùng cái bảo hiểm nhà của Thắng á, nó sẽ có cái đó cần, cái này cần nha, cần ép vô một cái clause gọi là short term rental clause. Chứ không là không được á, không là có những cái rủi ro khác cho Thắng á. Cái này cần nha Thắng, mà cái ép vô cũng tốn không nhiêu á, tốn mình nghĩ, mình không nhớ rõ nha, nhưng mà mình nghĩ chắc khoảng $100, $200 một năm mà.
Ok, vậy không đến đó nào.
Rồi cái layer thứ ba là cái layer gọi là umbrella insurance. Cái này thì anh nghĩ là ông Bob cũng có nói hồi nãy ha. Thì cái umbrella insurance mà cũng có nói luôn là cái nhà này mình có cho mướn short term rental, cho tôi umbrella insurance cho nó biết.
Nha. Anh Steven nói mới nhớ là tại vì có nhiều người á mua nhà cho mướn, không nói Airbnb short term, nhưng mà em nói có nhiều nhà mua cho mướn á, không có mua rental insurance, chỉ có mua, người ta nghĩ là home insurance đủ rồi, không có mua rental insurance. Thì lúc mà lỡ mà chuyện gì á, người rental mà làm chuyện gì xảy ra đó thì home insurance không có trả. Cái này có rồi nha. Tại home insurance nó nói á, là cái này không phải là bạn ở mà bạn cho mướn.
Mình có, nếu mà cái này dính tới long term rental á, thì mình
cho em hỏi một trường hợp đi, thí dụ bây giờ cái nhà anh 3 phòng, anh xem
một người hỏi
giống vậy luôn nè. Trong trường hợp này, nhưng mà em cho cái ví dụ luôn là thí dụ nhà bà 3 phòng, rồi anh share cái phòng master ra, rồi cái người rent đó làm trái nhà, thì sau khi trái nhà home insurance có đền không, hay là phải mua rental insurance?
Thì mình nghĩ có hai phần trong đây. Một cái phần á, là property damage á, thì cái rental insurance á, nó sẽ cover. Thành ra khi mà em ký hợp đồng với cái người tenant á, em request cái người tenant mua cái rental insurance, mà cái rental insurance nó khá rẻ ha. Bây giờ trở về cái trường hợp Airbnb để mình nói hết luôn là gì nè. Một cái layer nữa, layer thứ ba đi, nó gọi là cái layer gọi là umbrella insurance, là mình được 3 layer ha. Còn layer thứ tư á, là platform insurance, thì trong đó là Airbnb nó có cover ha, Verbal nó cũng cover, Booking.com cũng cover. Thành ra nếu mà dưới 4 layer, 3 hoặc 4 layer như vậy á, thì khả năng mà nó đánh tới LOC á, rất là thấp. Tại vì nó giải quyết tất cả những cái trường hợp đó trước khi vô tới LC, mà LC là giải quyết không được mà thưa nhau. Mình không có nói là nó giải quyết được hết, nhưng mà at least là giải quyết được cái rủi ro. Còn hồi nãy giống như ông Bob ông có nói là để mấy cái đồ trong gara bị ăn cắp nữa, thì mình nghĩ là lúc mà làm á, mình làm những cái lớn á, thì phải có cái construction insurance, chứ cái insurance thường nhà mình á đâu có cover cái đó, hoàn toàn không có cover. Lúc mà Thắng sửa nhà mà sửa nhà lớn đâu có cover, Thắng phải mua cái construction insurance chứ, cháy nổ bị gì thì cái đó nó cover, chứ nhà trống tụi insurance nó không có cover. Cái home insurance của mình á, đặc biệt là cái đợt 2008 2009 á, nhà trống quá trời, tụi nó không có cover.
Trong 4
cái này là đang không biết bảo hiểm sao nha. Thì như ông Bob nói là bảo hiểm nó sẽ tìm cách cớ nó deny lúc mà nó không có kia, nó không trả cho mình. Thì đó đúng đó. Tại vì Dan có gặp Dan có làm đó là cái nhà kia là bị phá bởi renters, đập phá hết. Thì là cái này là gì, về phần mà người ta trồng cần á, hồi xưa nha, là người ta mới lấy nhà rồi ta trồng cần, thì lúc mà trồng cần xong nhà phá banh hết. Nhưng mà cái anh này thường á, nếu mà có rental insurance á, thì là rental đã trả tiền lại rồi. Nhưng mà tại vì ảnh có home insurance, và ảnh home insurance á, thì ảnh không có khai láo. Nghĩa là nếu mà home insurance á, nếu mà ảnh khai á, ảnh gửi vô nói là ảnh là người ở đó thì hay gì khác không biết khao. Nhưng mà ảnh nói là ảnh cho mướn, và ảnh là người ảnh cho mướn và người renter đã vậy. Thì home insurance á, không có khó quan trọng á, là cái nói property này á không có cover cho những người mướn. Thì hoàn toàn những cái gì mà cái người bạn mà là dùng nhà trồng cần nó phá, là ảnh phải bỏ chi phí ra cỡ 50.000 để sửa lại. Thì cái chuyện đó là như anh Steven đã nói á, là bạn làm phần nào thì mua bảo hiểm phần đó. Tại bên Mỹ mình nghĩ cái gì cũng có bảo hiểm hết trơn á. cầu thủ đá banh mà cũng có bảo hiểm cái chân cái tay thì bảo hiểm rental insurance, short term insurance là bảo nếu mà người lo là ai thì nên có bảo hiểm.
Anh nghĩ là nó có tới 3 cái insurance luôn, nhưng mà để trả lời quickly trả lời cho Thắng là Thắng raise a very good point á, là nhiều khi mua nhiều quá, cái cost nó nhiều quá tính không có lời, thành ra mình phải balance sao, cái đó mình agree chứ không phải là nhắm mắt mà mua quá rồi cuối cùng tính ra là nó không có lời ha. Nhưng mà trong cái nhà nó có tới 3 loại là cái homeowner insurance là mọi người đã biết rồi, cái for DO5, HO5 gì á, rồi có cái renter insurance gì á, cái landlord insurance nữa nha, có cái landlord insurance nữa. Thành ra tùy ý mấy bạn, cái này mình không phải nói là mua nên mua hay không, là tùy ý nha, cái này mình không có khuyên gì hết, nhưng mà tùy ý mấy bạn research đi, nó có 3 cái policy. Renter insurance là dành cho cái người renter, landlord insurance là dành cho cái người landlord, và homeowner insurance là dành cho homeowner. Mỗi cái nó sẽ cover different. Rồi mình nghĩ là để dành đó cho một cái bạn bảo hiểm nào mà really chuyên nghiệp nói thì hay hơn mình, tại vì mình nói dành mối uổng lắm, để mấy bạn nói rồi mấy bạn giải thích rồi mấy bạn có gì mấy bạn giúp khách.
Nếu mà có cái bạn nào bảo hiểm đang coi trên cái livestream này cho mình hỏi cái câu này nha. Ví dụ như bây giờ tenant Airbnb nó đậu xe trước nhà mình, cái cục đá đâu văng bể kiến, cái nó đi đâu về nó nói là do nhà mày làm xây dựng nên đá văng bể kiến xe tích là của tao, vậy thì mày phải đền sửa xe của tao, mà tao thấy xe tao trước khi đi á là sạch sẽ, bây giờ về chày trộn lâm bể kiến, mày phải có trách nhiệm sửa nguyên cái xe này cho tao. Em nói là để mày lên bảo hiểm của mày đi rồi tao trả deductible, thì nó là let me consult with the lawyer. Thì có loại bảo hiểm nào trả cho sửa cái xe đó của người tenant hay không? Đó là câu hỏi của em.
Thì anh nghĩ là một trong landlord hoặc là renter, một trong hai nó cover.
Mời hai cái anh. Ok.
Nha, một cái ví dụ như renter muốn, anh nhớ không làm.
Nhưng mà tại vì em tại vì chiếc xe là personal property, thí dụ như nó phá cái nhà của em thì maybe là bảo hiểm nó cover, còn cái xe đậu ngoài sân thì em sợ.
Thì cái renter anh nhớ không làm nha, không biết có đúng hay không, mấy bạn bảo hiểm giúp mình nha, mình không nhớ chắc đúng. Theo mình nhớ không làm là cái renter insurance nó sẽ cover cái personal property, giống như là trộm cắp vào lấy đồ của renter được cover. Còn cái landlord insurance là nó cover
anh Steven phải coi lại nha, có hai thứ. Nếu mà đồ vật của personal mà đậu lên cái property của rental property đó thì cover, còn nếu mà đồ vật của đó đậu ở public street thì làm sao? Nó có hai cái nha, tại vì bảo hiểm lúc vô
mình không có rõ đây. Mình không có rõ, mình không có câu trả lời, phải đọc kỹ lại chứ cái này vô detail quá đâu có nhớ.
Tại em biết là bảo hiểm á, lúc mà nó chỉ cover cái property thôi, cho dù bảo hiểm nào rental short term gì là nằm trong property, có nghĩa là nếu mà nằm trong parking driveway là trong cái property thì nó cover, còn nếu nó không thể nào mà cover public hết trơn á. Tại vì nếu mà anh đậu ngoài đường, ở đường chuyện gì sao nó không có control được chuyện đó. So tất cả đó là mỗi cái short term ở kia là em thấy là cost toàn là vậy không á. Anything nếu mà có được nó nằm trong cái property, còn mấy bạn bảo hiểm này mà có biết cái lời nói gì mình thấy là giống vậy.
Rồi thì mình nghĩ là mình không phải nghĩ mà mình không có một câu trả lời chính xác cho nên bó tay, thì để dành cho thứ nhất là cái policy á, có cái policy người ta đọc kỹ, người ta giải thích thì đúng hơn. Cái đó mình không có câu trả lời, không nhớ rõ luôn, có nhiều chuyện quá.
Rồi ok, chắc thôi mình stop cái stream ở đây, hẹn gặp lại các bạn thứ sáu tuần sau đi ha. Gần đâu quá
nhiều cái câu trả lời đâu có trả lời hết được, quá trời câu trả lời đâu có trả lời hết được. Rồi vậy chị Delphine,
cảm ơn chị Delphine, cảm ơn anh Steven, anh Dan ơi, thông báo luôn thứ sáu tuần sau là cái gì vậy anh Dan?
Thứ sáu tuần sau mình sẽ thông báo, nhưng mà cái này là một chương trình rất đặc biệt. Nếu các bạn là developer nha, là người construction developer muốn gọi vốn EB5 gì mà không biết sao, không biết gì EB5 gì không hiểu gì hết trơn đó, thì thứ sáu tuần sau là mình có livestream với một công ty chuyên làm gì món đó, mà họ sẽ chỉ cách cho những, hay là bạn đầu tư EB5 riêng muốn làm tự làm vậy, họ chỉ hướng dẫn bạn, hay là EB3 luôn, nếu mà muốn làm EB3 họ cũng hướng dẫn bạn tự làm. Nếu mà bạn làm cũng như bạn có họ phải hướng dẫn, mà tại vì họ làm thì tốn công rồi, nhưng mà bạn tự làm là đường hướng mà đi thì cái đó. Còn mấy như những anh chị nào mà chủ đầu tư muốn làm develop land hay cần gọi file đó, thì một năm qua là tụi Dan đã làm research rất nhiều về topic này, tại Dan chính là cũng là làm gì đầu tư và cũng muốn thử gọi file, thì Dan biết rất nhiều, cho Dan chia sẻ tất cả gì Dan biết để với bạn. Thì người nào làm được làm thôi, Dan không có giấu giếm gì hết trong cái phần mà muốn gọi vốn EB5, mà phải làm cho đúng thôi. Để cho hy vọng là Việt Nam mình làm cho đúng để có cái lòng tin hơn. Tại vì cái đó là tại vì giống như những công ty khác, như công ty như Dan nói hoài, do Thái đó làm rất đúng lắm hay, thì mình phải học từ những cộng đồng bạn. Nghĩa là thứ sáu tuần sau Mời chị Đẹp Phi lên nữa cho anh Steven lên luôn hả? Nếu mà
mình không có dám hứa, nhưng mà khi nào nếu mà có một chút
7
thời
giờ
gian
rưỡi
á,
anh.
thì mình sẽ cố gắng.
Yeah,
Mình ngại là mình
tại vì
hứa
cái
rồi mình
này
lên
7
không
giờ
được bất
rưỡi
kỳ.
tới 8 giờ rưỡi giờ Cali sẽ nói về những cái chương trình này, hoặc là nói về cái phần này rất là đi sâu vào luôn. Thì bữa nay nếu bạn coi YouTube Nhạc Cửa Mỹ thì đã có một cái video về có một anh Trung, là ảnh là người đầu tư EP5 bên Việt Nam mà tự làm ha. Ảnh tự làm, không phải là tự làm gì mà ảnh tự tìm luật sư, tự tìm dự án, tự underwrite dự án, nói thẳng dự án, rồi rất là khá lợi hại. Để lúc mà đem về Việt Nam anh gặp anh nó, và anh quay lên nó wow, anh này em có thể hiểu được một người bên Mỹ làm được chuyện đó, nhưng mà Việt Nam không biết làm vậy. Thì em nghĩ là cái này là tại vì thiếu thông tin thôi, nhưng mà ảnh được thông tin thì ảnh làm được là một video đó. Video thứ hai á là EP3. Thì trong thị trường bây giờ mà mấy lùm xùm mấy như là cả năm nay rồi ai cũng EP ra rồi nói tới tung hết trơn mà không có hiểu là thế nào, thì tôi đem ra có một cái video cũng về EP3. Cái EP3 là sao, là sao có thể tự làm hay không. Tất cả những chương trình EP5, EP3 đều có thể tự làm hết, nếu bạn có đủ kiến thức và thông tin. Chỉ chừng cần mà không đủ kiến thức và căn tin đó thì mới qua một công ty nào khác làm đó. Còn bởi vậy thì đó là Dan đã mà làm hai cái video đó, bạn coi trước. Nếu mà bạn mà muốn dự cái livestream từ sau từ 8 giờ rưỡi đến 9 giờ rưỡi, em xin mời anh Steven với chị Daphne lên bữa đó luôn, nếu mà anh chị có thể.
8 rưỡi hay 7 rưỡi?
7 rưỡi tới 8 rưỡi giờ Cali.
7 rưỡi giờ mình á.
Cố gắng coi có lên được không, sợ bận quá. Nhưng mà sẽ cố gắng thôi, không dám hứa.
Rồi anh Steven bận quá, anh
bữa
retire
nay
rồi,
cũng rất là
bận gì
lên
nữa. Anh retire rồi, mọi người retire bận hơn người đi làm á.
Tại vì có mấy cái linh tinh mình phải làm á, nên mình không buông được. Hy vọng tới 2026 đi, 2026 thì mình sẽ rảnh khoảng 3 năm nữa, mình nghĩ sẽ rảnh hơn.
Trời ơi, bây giờ mà hẹn 2026.
Nhưng mà để cố gắng.
2026 tháng đen là về hưu rồi.
Anh đi mình hẹn giống trong phim Tàu á, đưa tới ngã ba, hẹn 3 năm nữa gặp lại cái sư đệ. Em xa dữ vậy.
Không, mình cố gắng lên chứ, nhưng mà nhiều khi á, giống như hồi sáng này mình cũng hơi ngại là mình có nhiều chuyện quá nên mình không có lên đúng giờ được, hơi ngại ra hỏi. Nhiều khi có những câu Dan đã hỏi rồi mình hỏi lại nó hơi overlap, tội nghiệp một sự.
Ok, vậy thôi, giờ mình tới end đi ha, thì tụi mình phải đi làm chứ.
Lên nó fit nhanh lên, lên nó fit liền ha.
Bye
Rồi bye mọi người, cảm ơn anh chị.
Rồi, cảm ơn.